I was supposed to sweat, so I turned it down. Did it over here. Oh, sorry.
I'm gonna pull some files here for the ones that are here in the front row.
Justin Hughes.
Okay.
Brad Weathers.
Yeah, over here, front row.
Don Hamilton.
We have a good address for you. Can we have a good address for your mailing address?
300 16.
300. Here.
session. The Honorable Andrew Wheeler is now presiding.
Thank you. You can be seated. Dylan Hamilton. How you doing, Mr. Hamilton? Good, how are you? Good. I wanted to get you called because you were one of the folks that were in compliance and reviewing the documents. We last had you in court back in December. We did see that you had started your treatment at a better way. 6 sessions attended overall. Progress assessed as fair. Looks like you had some attendance issues, so just try to get that straightened out if you can. We're going to have you back on July 13th. Please just keep making sure that a better way is filing those monthly reports. We'll get you a copy that has that return information on it. Keep up the good work. Okay, thank you. Thank you. Is Al Thorson in the courtroom? All right, so I know you have a couple matters, Mr. Johnson. Do you have a preference for the order you call them?
I have a lot of pieces, Your Honor. Why don't we start with a couple of simpler ones? So I have, we're really very last time, President.
Okay, sounds good. Mr. Lusk, can I have you state your name and date of birth, please, for the record?
Vernon Scott Lusk, October 18th, 1967.
Okay. Present with your attorney, Mr. Johnson. Mr. Johnson, how are we asking to proceed?
Your Honor, my request would be to set this to another docket to do an entry of deferred prosecution. He does explain to me that he did complete an evaluation for deferred prosecution. However, it was done through Lifeline, and I have not received that evaluation as of yet. And so we're following up with that to get a copy of the evaluation in order to enter deferred. I anticipate being back on the 27th. If that works for the court and for the city, that would be my proposal.
Looks like speedy trial just commences today, Ms. Carney. So any objection to the 27th for the formal entry?
No objection, Your Honor.
Okay. So Mr. Lusk, we're going to see you back here for your next mandatory court date on the 27th of April, 2023 at 1:30.
Okay.
Release conditions that have been previously imposed in your case will remain in place. Please make sure you're staying in contact with your attorney, Mr. Johnson. And it sounds like we're nearing the final steps on your case at this point.
Yes, Your Honor.
We're going to get you some documents over by the door. Once you have them, you're free to go. Thank you.
The next, Your Honor, would be Sergey Glushko, and he should be present on Zoom.
Not seeing the waiting room. Sometimes that's just on me. We have Mr. Glushko in the waiting room.
No, Your Honor, I don't see him.
I don't think we have anyone in the waiting room uniquely. Oh, we can bring him in. He's a very quick matter. So if the hold off, it sounds like on Mr. Glushko.
No
Do you have
problem.
another shorter matter, Mr. Johnson?
I do. So another one would be Richard Mendoza. President, on forward.
And Mr. Mendoza, if I can have you state your name and date of birth, please, for the record.
Richard Mendoza, 62484.
Okay. Go ahead, Mr. Johnson.
Your Honor, I would ask to do a set over on this matter, a continuance of approximately 90 days. Defense investigation is still ongoing, as well as we're gathering some mitigating records to present to the city. So with that said, if July 6th was open to the court, that would be my proposal. That works for the city.
I know that's a date
Ah.
that your preference was to keep a little bit lighter in regards to readiness hearings,
Yeah.
is my recollection.
Would there be a date either a week before or a week after? I'm just gone. So I'm trying to limit amount of work I do on vacation.
That's fair. No problem at all. I can do the 20th or the 27th of July, either or.
Either works for the city.
Yeah, both are available. Your choice, Mr. Johnson.
Okay, I would propose July 20th, Your Honor.
Okay. Mr. Mendoza, have you had the opportunity to discuss with Mr. Johnson your right to a speedy trial?
Yes, ma'am.
You understand that doing a waiver starting July 20th, you'd be giving the city of Battleground 90 days from that date if it became necessary to bring you to court. Actually, I already just filled it out.
Okay, sounds good, Your Honor. Thank you.
Okay. I will accept the waiver, find it knowing, intelligent, and voluntarily made. Mr. Mendoza's next court date is going to be on July 20th, 2023 at 1:30 p.m. Mr. Mendoza, just like today's court date, that is a mandatory court date. So if you fail to appear, a warrant can be issued for your arrest. Conditions of release on the case, including the enhanced pretrial release, random UAs, interlock, no consumption, and no driving without a valid license will remain in place. We're gonna get you some paperwork over by the door. Once you have your paperwork, make sure you're staying in good contact with Mr. Johnson. You're free to go.
Yep, thank you. Wait, right over there. And then, Your Honor, one more would be Charles Segal. Your Honor, I'll hand up the speed trial waiver on this one.
Okay, great. Thank you.
This is the date written in based on what we decide.
Is Mr. Stegall here?
He's gonna be present on Zoom, Your Honor. Or he should be.
There he is.
I'm going to call Mr. Thorson while we're waiting for Mr. Stegall to connect Mr. Johnson, just to let you know.
No problem.
Mr. Thorson, if I could have you unmute, sir. Turn your camera on if you can.
Yes, Your Honor, I'm here.
Thank you. Can you state just your name and date of birth, please, for the record?
01/08/1984.
And Mr. Thorson, I was calling you early because you were another person that on our docket for the review docket this afternoon that was in compliance. Just noting at this time that you've completed your treatment at Lifeline as of March 17th. Congratulations on that.
Thank you, Your Honor.
You're compliant with your DV treatment. Perfect attendance, it looked like as of February, so hopefully that's continued, but overall, you're just doing a great job.
Thank you so much.
We're gonna set you over to the July 13th docket.
Okay.
Certainly expecting still to have continued good things from you, Mr. Thorson. Have a mailing address for you that we were gonna be sending documents to that I just wanted to confirm on 72nd Avenue in Vancouver. Is that still gonna work for you?
Yes, Your Honor.
All right, we'll send the paperwork there. Keep up the good work, sir.
All right, thank you so much. You have a great day.
And Your Honor, if we have Courtney Foster, I think that's the only case Mr. Busby needs to be heard on this morning
Okay.
or this afternoon, excuse me. Who? Oh, okay. Does Ryan know that? Should I tell Ryan? Okay.
Okay, so is Mr. Stegall connected?
Yes, sir, I'm here.
Great. Can you turn your camera on, please, sir?
Let's see, how do we do that? Can you see me? Oh,
No.
start video. There we we go.
Okay, can I have you state your name and date of birth, please, for the record, sir?
Charles Stiegel, July 20th, 1988.
Okay, Mr. Stiegel, you are present in court. Your attorney, Mr. Johnson, is also here. Mr. Johnson, go ahead.
Your Honor, I was going to ask to do about a 60-day set over as defense investigation and negotiations are still ongoing. I would propose the date of June 8th, if that works for the city. He'd be willing to do a speedy trial waiver commencing that date.
Ms. Carmy, just very briefly, sorry to interrupt you. Is June 8th okay for a return date for Mr. Stiegel with a commencement the same day?
Yes, Your Honor. Thank you.
Okay, sorry again to interrupt.
Nope, no problem.
All right, so Mr. Stiegel, we're going to be having you back here on June 8th, 2023 at 1:30 p.m. It's going to be a mandatory court date, sir. It sounds to me like you are also requesting to commence or begin your speedy trial that same day. Do you understand your right to a speedy trial, Mr. Stiegel?
Yes, sir.
And are you in agreement to begin that speedy trial running again on the 8th of June?
Yes, sir.
All right, I will accept your waiver, sir. I'll find it knowing, intelligent, and voluntarily made. Again, your next court date, June 8th, 2023. Any previously imposed release conditions will remain in effect on the case, including administrative pretrial release and the random UA condition and no consumption condition. We're going to be mailing you, sir, your paperwork. Are you still getting your mail at the address on South 69th Place in Richfield?
Yes, sir.
All right, we will send the documentation there. Anything further on Mr. Stiegel's case?
I think that covers it for defense, Your Honor.
Okay. All right, Mr. Stiegel, you can log out. Thank you, sir.
Thank you.
Judge. And Your Honor, regarding Sergey Glushko, he slipped in while I wasn't looking, so he's actually present here in person.
Okay, yeah, we can bring him up. All right, sir, and if I could have you just state your name and date of birth, please, for the record.
Sergey Glushko, 05/30/1997.
Okay, thank you, Mr. Glushko. Go ahead, Mr. Johnson.
Your Honor, what I propose that I've discussed with the city is setting this to April 27th, so a 2-week set over in order to resolve. We're just finalizing some final details here on this case. So I believe we should be good on speedy.
Any objection, Ms. Carmen?
No, Your Honor. We did discuss that in the city as an agreement.
All right, Mr. Glushko, your next mandatory court date is going to be on Thursday, April 27th, 2023 at 1:30 p.m. That is a mandatory court date, sir. If you fail to appear at that time, a warrant could be issued for your arrest. Your interlock condition and your administrative pretrial release will continue. We're going to be getting you some documents here momentarily that have that return court date on it. Please make sure that you are maintaining contact with Mr. Johnson, okay? We'll bring you some paperwork over by the door. Once you have your papers, you are free to go.
And Your Honor, that covers it for my quick stuff. So if Your Honor wants to move on to other quick matters.
I'll probably try to take some more quick matters, then we'll get you called again. I know you have a few more, Mr. Johnson. Mr. Green, I see you on Zoom. Do you have a faster matter for us to do?
Relatively quick matter, Your Honor. This is actually the Courtney Foster matter. This is the one that Mr. Busby's handling.
Okay. Mr. Busby is with us on Zoom. Is Ms. Foster on Zoom? Is that your understanding, Mr. Green?
I think she should be in the courtroom, Your Honor.
Ms. Foster here in the courtroom? Courtney Foster? Yep. Okay, she's making her way forward.
Thank you, Your Honor.
Ms. Foster, when you get up there, if you could just state your name and date of birth, please, for the record.
Miss Courtney Foster, 06/10/2002.
Okay, you're very soft-spoken. We
Sorry.
do have a microphone, but if you could just speak up just a little bit, I would greatly appreciate it.
Yes.
All
Courtney
right, we are
Foster.
joined by your attorney, Mr. Green here, who is present with us on Zoom. Also present is City Attorney, Mr. Busby. Go ahead, Mr. Green.
Thank you, Your Honor. Ms. Foster has attempted to do several days of work crew. Unfortunately, each time she signed up for those, apparently 4 or 5 times she showed up and the work crew had been canceled for that day. However, Ms. Foster is signed up for the remainder of the work crew for this weekend. As I understand this, she will complete work crew on Monday. In addition to that, Your Honor, Ms. Foster has documentation showing that she has been engaging in anger management treatment. She should be able to provide that documentation to the court right now.
You have some documents. Do you mind if I take a look at them? Great. Thank you very much. All right. And I'm always careful. So the first document that it was handed forward, it looks like, is a time card regarding community service. It looks like that community service obligation has been completed. Recommended time was 40 hours. Second thing we have. So I'm certainly, I appreciate you handing this forward. Did you get do an evaluation yet?
Yes, I did. I did one actually given to me. I was actually just able to sign in onto my chart and it said the March 27th, I had a 40-minute evaluation. And my mom was supposed to get it sent in today, but I
Who is that taking place with?
Can't remember her name right now.
Are they a state certified evaluator?
Yes, they are.
Okay, in Washington State?
Yes.
Okay. So I don't want to, because this is some of your personal stuff, I'm not going to keep this for the court file. Simply because it becomes public record. So I'm going to keep your community service documentation. I'm going to put this up here if you want to take these documents back, just because, again, that looks like it's subject to physician-patient privilege. Mr. Busby, overall city's position regarding the updates on Ms. Foster, it sounds to me like she is a little bit soft-spoken, that she has an evaluation scheduled on the 27th, if I'm hearing correctly. Okay.
And I also,
And did she complete the anger workshop?
yes, I did, but I have to bring it on paper because of the website that it's on didn't allow me to basically complete it on there. I have to bring it in on paperwork.
So she's saying that she did complete it, but she needs to get a printed copy of the form. So it sounds to me, and I'm going to intercede here, and I won't steal Mr. Busby's thunder. It sounds to me like near the end of April, a lot of these components can be provided to the court. So my inclination, gentlemen, if you're in agreement, is to set this matter over to about the second week in May. That point, we should have documentation regarding the anger evaluation, and we should have documentation regarding the workshop. Is that
Okay.
fair to say?
Yeah, I mean, sooner would have been better, but that's fine, yes.
Well, if your evaluation, you're saying is not till the 27th.
Of this, well, that one I meant, so like March 27th, that one was.
So you've done an evaluation?
Yes, but I have another one that was set today, but I wasn't able to do it today, so I have it for Monday.
So you're going to be evaluated on Monday?
Yes, but I've already had a one, like I had a 40-minute one, March 27th. I have to get that on paperwork. My medical care was messing up and I didn't get it done till March started. And when that was done by March 27th, I got a 40-minute one done. Then they made another one with me for today, but I couldn't do it. So I had to, like, that's why I stepped out. So I had to make another one for Monday for a 90-minute one.
And you're actually doing an evaluation?
Yes, an evaluation.
Okay. So it sounds like the evaluation is going to take place on Monday. Sounds like we're going to have printed documentation regarding the anger workshop.
Yes.
We have the community service done. And so you're asking to come back sooner. Do you want to come back on April 27th, Ms. Foster?
Yes.
Mr. Green, will that work for you, April 27th at 1:30?
Just double checking here, Your Honor. Yes, Your Honor, that works for me as well.
Mr. Busby, does that work for you?
It does, Your Honor. My request would essentially be that this is kind of the last chance. We've been here a number of times with documentation supposed to be provided. We get to court with kind of a similar, I don't have the documents yet. And so the city's position would be that this needs to be kind of the last chance, or else the city wants to move forward with the motion to revoke.
I'm gonna be honest with you, Ms. Foster, I agree. You're
Yeah.
doing some of the stuff, but it seems to me like for an adult, you should be able to get moving a little bit quicker, okay? So we're gonna see you back here on the 27th of April, 2023. That's gonna be at 1:30 PM. Any documentation that you get that you want to provide to us early on, do so. We can review it all as early. You don't need to hand deliver stuff. There's an email address. You can contact our court clerks. You can always file stuff in advance, okay?
Okay.
All right. So we'll be getting you a document that has that return court date on it. Please keep in mind, there's a couple of things that the court will be looking for at that next court date, okay? All right, thank you, ma'am.
Thank you, Your Honor. That's my only matter.
Yeah, thank you. Ms. Wegener, do you have a matter ready?
I do, Your Honor. I have the Garrett Daniels matter.
Okay, is Garrett Daniels in the courtroom? Or maybe on Zoom if we could.
I see somebody connecting to audio with a G.
That's
There he
him.
is.
Mr. Daniels, if I could have you unmute, sir, and turn your camera on, please. Thank you, sir. If you could state your name and date of birth, please, for the record.
Garrett Daniels, 6/27/1997.
Okay, Mr. Daniels, we are joined via Zoom by your attorney, Ms. Wegener. Ms. Wegener, how is Mr. Daniels asking to proceed?
Your Honor, we're asking for a continuance in this matter. You might remember that this has a CPS component that is separate and distinct from this.
You are muted, Ms. Wegener, just to let you know.
Oh, I am. Well, let me start over then. Your Honor,
You're reminding me of a CPS component. I did recall that, and then you went on mute, so go ahead from there.
Oh, strange. I did not do that. Your Honor, he has another attorney that's working on his behalf in the CPS case. When I spoke with Mr. Daniels, it sounds like that hearing has been pushed off to the end of April. And he would like some additional time to consult with that attorney, as would I, prior to me responding to Ms. Carmi for the offer that's currently on the table. Ms. Carmi's offer includes certain types of treatment. I'd like whatever treatment program he might be doing for CPS to also coincide with whatever resolution we work on through this case. So we're asking for a continuance. Thank you.
And just to make sure I'm understanding, so is Mr. Daniels going to be doing a speedy trial waiver to facilitate that?
We're happy to. I can verbally acknowledge that he would commence speedy at the next court date and extend beyond that time for 90 days.
Okay. And looking at your calendar, Ms. Wegener, do you have a preferred date that you would like to schedule that return date on?
Is it every Thursday, or what dates are available?
Yeah, we only have municipal court on Thursdays.
If we set it to the the May 25th date in the afternoon, would that work with the court's calendar?
Ms. Carmi, any objection to setting to May 25th with the waiver commencing that day?
No, Your Honor.
Okay, doesn't sound like any objection from the city. I'll be here no matter what on Thursday, so I'm fine with having that take place. So, Mr. Daniels, we're going to have doing a couple of things. Number one, have you been able to talk to Ms. Wegener about your right to a speedy trial?
Yes.
Do you understand that doing a commencement date of May 25th would give the city of Battleground 90 days from that date if it became necessary to bring you to trial? Do you understand that?
Yes, Your Honor.
And are you in agreement with doing a waiver starting that day?
Yes.
Okay, I will accept the waiver. I'll find it knowing, intelligent, and voluntarily made. Mr. Daniels' next court date is that same day, May 25th, 2023 at 1:30 p.m. That is a mandatory court date, sir, meaning if you fail to appear at that time, a warrant for your arrest could be issued. At this point, the pretrial release conditions, including the enhanced pretrial release, will be remaining in place. Are you still getting your mail, sir, at the address on Grace Avenue?
Yes, Your Honor.
Okay, we will mail your documents there. Ms. Wegener, anything further on Mr. Daniels' case?
No, nothing further. Thank you.
All right, that concludes your matter. Mr. Daniels, you can go ahead and log out. We'll mail you your paperwork.
Thank you.
Thank you. Mr. Ritchie, do you have a matter ready?
Yes, Your Honor. I have Nicholas Wilson.
Okay. Mr. Wilson, if I could have you turn your camera on, please, sir. Thank you, sir. Could I have you state your name and date of birth, please, for the record?
Nicholas Wilson, December 14th, 1989.
Thank you, Mr. Wilson. We are joined also on Zoom by your attorney, Mr. Ritchie. Go ahead, Mr. Ritchie.
Yes, Your Honor. I've been in communication with Ms. Carney, and I think I know that we now know the direction that we'll take to get this resolved. We just need a little bit more time. I need to discuss it with Mr. Wilson. So if we could set it over about a month or so, that would be fine. And then I believe we last waived on March 2nd. So we may need a new speedy trial waiver. I'm sure Mr. Wilson's willing to do that.
Mr. Wilson, have you discussed your right to speedy trial with Mr. Ritchie, sir?
Yes.
And to facilitate setting your case over an additional month, would you be fine with doing a waiver that begins at that next court date?
Yes.
Okay. Mr. Ritchie, in looking at your calendar, do you have a proposed date that you would like to schedule Mr. Wilson's next court appearance?
Let me take a look here, Your Honor. Let's see. Could we set this on the 11th of May?
That would be fine for me. Any objection, Ms. Carmy, to setting Mr. Wilson over to the 11th of May?
No objection, Your Honor.
Okay. So, Mr. Wilson, the proposal is to do a commencement of your speedy trial as of May 11th, 2023. Again, that would give the city of Battle Ground 90 days from that date if it became necessary to bring you to trial. Do you understand that right to speedy trial?
Yes.
And are you in agreement to waive that right?
Yes.
We'll accept the waiver, find it knowing, intelligent, and voluntarily made. Mr. Wilson's next court date is May 11th, 2023. That's going to be at 1:30 p.m. That is a mandatory court date, Mr. Wilson, meaning if you fail to appear at that time, a warrant for your arrest could be issued. Release conditions in the case of recognizance just remain in place. Mr. Wilson, are you still getting your mail at the address on Northwest 7th Street?
Yes.
All right, we will send your documents there. Anything further, Mr. Ritchie?
Nothing further. Thank you, Your Honor.
Great. You both can log out. Have a good day.
Thank you.
Thank you. You too.
Do we have Kylie Bernard? I think that's the only case Ryan's waiting on. Well,
Was he told that court
I
started?
may have a couple more too, Ms. Carmy.
oh, do you? I'm sorry. Okay.
No worries.
Okay. Is Autumn that's joining us on Zoom, is that Ms. Nigro or someone else?
Yes, Your Honor, it's me. I'm not sure why it's dropped my last name.
Just going a little bit more informal this afternoon. I understand, not a problem. Which matter are you here on, Ms. Nigro?
Jordan Smith.
Okay. Jordan Smith present? Yes. All right, Mr. Smith, you come forward, please, sir. And if when you get up that rostrum, you could just state your name and date of birth, please.
Jordan Smith, 9/12/68.
All right, Mr. Smith, I have some documents in front of me that are what is called a stay agreement. Have you had time to go over with Ms. Nigro this stay agreement?
Yes.
Okay. The first thing I tell all folks that are entering a stay is that I'm not a party to it. This is specifically a contract between yourself and the city of Richfield. My role is to make sure you understand the terms of the agreement, meaning the things that you have to do, then hold the city to their responsibility, which is to dismiss your case if you meet those terms, okay? So with that said, sir, you and I are going to go over this agreement. If you need additional time to talk to Ms. Nigro during this proceeding, just let me know and I'm more than happy to give you some additional time, okay? All right. There are some financial obligations, sir. There is a filing fee of $150, a pretrial supervision fee of $150, and there may be some restitution owed to Safeway. Certainly for those certain fees, you are on a payment agreement with the court. The restitution is something that'll be looked into and possibly could be held open for about 180 days to see if that's requested by Subway. You maintain compliance with your court payment plans. You are to complete 24 hours of community service. That can be at any nonprofit you choose. You need to provide documents to the court, though, so we have the agency and a contact person to verify your compliance with that. You're not to have any new criminal charges and have good behavior. The charge which you are entering your stay on is what is called a simple misdemeanor, sir. It's subject to 90 days in jail and a $1,000 fine. You are giving up some important rights in entering your stay, the first of which is your right to a jury trial. Do you understand that right, sir?
Yes.
And you understand that you're giving that right up?
Yes.
Okay. The second thing that you are doing is you are giving up your right to a speedy trial. Do you understand what that means, sir?
Yes.
And you're setting what is called a new commencement date of April 13th, 2024. Are you in agreement to have that be the day the 90 days starts running again?
Yes.
Okay. And it doesn't look like on the stay agreement that it's indicated as a gross misdemeanor. If the parties are okay, I'm going to change it to a simple misdemeanor just in regards to the maximums. Any objection to that?
No objection.
Okay. Just going to initial by those two parts real quick. Okay. I have an electronic signature of a Jordan Smith on the document. Did you electronically sign the stay, sir?
I did.
Okay. We're going to set a return date for July 13th, 2023. At that return date, we're going to be getting some information regarding the completion of your alternative community service. So my hope is in the 3 months, you have those 24 hours almost done. Certainly, if there's restitution, we can also look at it at that time as well. The easiest way to cancel that date, if you want, is to have the documentation showing your community service is done, and oftentimes the court can cancel that return date.
Okay.
Your final court date is going to be April 18th, 2024. At that time, if you have completed all your conditions, the charge itself will be dismissed. Any questions of the court before I sign you into the agreement?
Nope.
Okay. We're going to be getting you copies of the documents, sir. Once you have your copies, you are free to go. Good luck. Anything else, Ms. Nigro?
No, Your Honor, thank you.
Thank you. Have a good day.
You too.
Mr. Walker.
Just in here.
Okay,
Your Honor, I'll approach with orders on those.
sounds good.
Your Honor, just so the city can make a record in an unusual situation like this. This will encompass both of Mr. Hughes's cases, including the second in time for which Brandon Campbell is his attorney. Mr. Campbell is stuck on a felony docket, but I have discussed this resolution with Mr. Campbell, and especially because of Mr. Walker's presence here, he is okay with us proceeding in this regard. The city is moving to dismiss both of these cases without prejudice. Both counsels on both cases have reached out to my office to arrange officer interviews for quite some time. The city has mailed certified letters numerous times to those material witnesses. We've made numerous phone calls.
So when you say officer interviews, you mean witness interviews?
Witness, thank you. I
Okay,
apologize.
no
We
problem.
did officer interviews.
My hope was the officer.
Thank you.
Okay.
Thank you, Your Honor. Officer interviews were done. It was those other material witness interviews that we cannot provide to defense. So at this point, the city feels like it has no other position it can take other than to dismiss without prejudice, refile if those material witnesses appear, and can be made available to defense.
Mr. Hughes, I'm just going to quickly state Mr. Campbell, as Ms. Carmi stated, is doing another hearing right now. Are you comfortable with him not being here for this proceeding?
Yes, Your Honor.
I mean, Mr. Walker's more than
Yeah.
capable, but we want to just make sure you're okay with that. Okay. I understand the circumstances. I think this was something that we all saw coming over the last month or so in terms of the availability of the witnesses. So at this time, it looks like that I have orders in front of me to dismiss the cases without prejudice. I'm assuming that Mr. Walker or Mr. Campbell has talked to you about that, what that means. It is indicated on the documents, the reason for the dismissals. Also terminating the orders with protected persons PMH, date of birth 10/18/2006, and protected person Pearl Hughes, date of birth 6/20/1982. So I will sign the documents. Mr. Hughes, you will get copies of it today. With the conclusion of these cases, any pretrial release conditions that you have been on through this court will end. Certainly, if things change, that they do preserve the jurisdiction to bring these cases back. So it is helpful if you do move and you just update your address, just because we'd hate to have a warrant just because you didn't know about something. Okay.
And then the,
I'm sorry, does that automatically recall the no contact order in this case?
I did a separate NCO termination order.
Yeah.
So that will terminate, but I will just say, just so your client is clear, it won't affect the underlying NCO from the family law case, which at least on my end shows it's still in effect through 2027, but it'll dismiss the ones from our actions. Yeah.
Anything further on this matter, Mr. Walker?
No.
Okay. Mr. Hughes, we're going to be getting you the documents that we referred to over by the door. Once you have your documents, you are free to leave. Thank you, sir.
Thank you.
Right, Mr. Johnson, I think we've gotten all the private attorney matters. I know that Mr. Campbell has some matters, but he's on another docket. So if you want to take this opportunity, we can call a couple of your cases.
Your Honor, thank you. I have 3 cases left, 2 of them resolutions, and one of them the arraignments. So I would propose we move it on.
Right. All right, Ms. Pack, if I could have you state your name and date of birth, please, for the record.
Don Pack, May 28th, 1982.
Okay. Ms. Pack, you are making a first appearance arraignment on 2 charges. A charge of interfering with the reporting of domestic violence, which is a gross misdemeanor subject to 364 days in jail and a $5,000 fine. Also a charge of assault in the 4th degree domestic violence, subject to 364 days in jail and a $5,000 fine. I have reviewed the associated police reports in the case. I have found probable cause for both charges. We do see that there's notice of appearance on file from Mr. Johnson, so confirm counsel. Mr. Johnson, how is Ms. Pack asking to proceed?
Your Honor, we are planning to enter pleas of not guilty to both counts, and then we're just asked to set dates in due course and waive a formal reading.
Okay. I will receive not guilty pleas on both counts. We'll assign future court dates. Going to assign an attorney pretrial. That is going to be on the 26th of April, 2023. Ms. Pack, that's a date for your attorney, Mr. Johnson. It's not a required court date for you. Your next mandatory court date, ma'am, is going to be on the 25th of May, 2023 at 1:30 p.m. That is a mandatory court date. If you fail to appear at that time, a warrant for your arrest can be issued. What we're going to do now is I want to deal with the tracking on the other cases, Ms. Carney.
Yes.
I also would like to discuss release conditions. You can do them in any order you want.
Okay, Your Honor, and then if I may approach.
Okay.
On those tracking cases, I have given a copy of this to Mr. Johnson. We intend to have Your Honor review and file this today. We wanted to wait for arraignment to occur on these 2 charges, these 2 new charges. This is a motion to revoke the stay from April 28, 2022, because it does allow for the city to move for that should probable cause be found in this court on any new charges during the pendency of the stay. So we would ask for that order to be signed and then set forward dates where we could deal with this motion to revoke readiness on the new arraignment, as well as any probation violations from the 2A DUI case.
And so is the intention, just so I understand, that the actual revocation proceeding / sentencing take place at the readiness date that we scheduled for the 25th of May?
Yes, Your Honor, we are asking to move forward with revocation based simply on the probable cause finding of the charges.
Understood. Mr. Johnson, do you want to be heard on that right now?
Your Honor, we did enter a plea not guilty. Our request would be for the show cause for the revocation to track the set readiness hearing date. So this is ultimately, this is ultimately a case, again, pled not guilty. I think defense investigation is going to be fruitful here. And so we just asked to pause any action on that front and would ask for it to track the new pending charge.
I'm going to discuss why I'm going to do what I'm going to do. I think that Ms. Pack, was given a miraculous opportunity already once before. And that was that she was on a stay, where alcohol was involved, got another alcohol related charge, the DUI, which she was convicted of, and was allowed to continue on the stay. And very clearly, language was placed in that stay agreement that did not say that the disposition was going to be based on a conviction, but simply probable cause being found, which is Mr. Johnson knows, which Ms. Carmi knows, is a very low bar. And it was not a very low bar in this case. So I am going to go ahead and sign off on the revocation of Ms. Pack's stay. I think that there is a good deal of grace right now being shown by the city and not asking to proceed with sentencing right now. That'll at least allow Ms. Pack to get whatever steps she needs to get in order prior to that hearing taking place. But I think there is more than enough information before this court to go ahead and revoke that stay. So I am going to do that at this time. We are going to be scheduling the hearing in regards to sentencing on the stay case for the 25th of May, 2023. That's to take place also at 1:30 p.m. So that'll be heard in concert with this case. I'm going to put on the return to court form right now all of the cause numbers that we have before this court on the return to court form, meaning I'm also going to be tracking the DUI case with this. Okay, so we have that, have made the finding on the stay. Let's now discuss conditions of release. Go ahead, Ms. Carmi.
Yes, Your Honor, in this case for this new alleged assault, we are asking for Your Honor to sign a replacement NCO from felony level. It's a bit unclear to me whether that survived exoneration, but I would note we're going to do our own in this court. I also note that there are underlying civil protection orders, and I do not believe ours conflicts with that in any way. It's simply no contact with the minor. We are also
Do you have
asking.
a draft copy of the NCO, the standalone one that you're asking for?
Yes.
Okay. Go ahead and approach with that. I apologize, continue.
No. And then because much like the prior two charges, the allegations involve alcohol use. We are asking for a Scram remote breathalyzer. We are not asking for random UAs, which was imposed again at felony level before this was exonerated. The city's concern is alcohol, and we think that the Scram remote monitor adequately assures the city that there will not be alcohol use, and if there is, we will be notified immediately.
And so you're talking about the BART rather than the transdermal monitor?
No, transdermal, Your Honor.
Okay, you said remote breath, so.
Oh,
trans-
I think that's
okay.
what it's called on this form. That's, no, I mean the transdermal.
Transdermal monitor.
Yes, thank you, Your Honor. I will also note that we reached out to the father of the alleged victim about whether the child felt like high-risk DV monitoring or victim notification was going to be requested. The father at this point did not indicate that that was his wish, so the city will strike that from its request. Certainly, if there were any issues, the city may request that down the road, but at this time we are striking that from our request. And then other than that, we are not asking for bail in this case. We understand that there was 15,000 already posted. We did note in the felony case there was a no contact with or not. Defendants should not be in any places where minors congregate. The city reached out to law enforcement who've been involved in this case. They did not have concerns about any predatory behavior that would warrant that type of condition. So the city is not asking for that to be re-upped for our cases.
Mr. Johnson.
Thank you, Your Honor. So we would be, as far as conditions of release go, we would, I guess, first point out, I think the fact of whether or not alcohol consumption or intoxication, the source of that information in the probable cause statement, I would just point out it stems from a report from the 10-year-old child, and it's really arguably unclear whether or not alcohol consumption was actually used in a factor in this case. In any event, historically, alcohol consumption Ms. Pack certainly does have a history of alcohol consumption, and with that said, we are in agreement with the use of Scram. She's had the Scram device installed and worn in previous cases with good success and without any violations. She has it today, and so we would ask, we do agree to the use of that, and we aren't objecting to that condition as it's already in place. We'd ask for the UA requirement to not be imposed, as with the Scram ankle monitor device imposed. We think the UA is.
I don't think Ms. Carmi was asking for the UAs, were you?
No.
So basically, we're in agreement. It's very important for her employment that the condition be dropped for her, the condition precluding her to be near minors or to be able to visit areas where minors are congregating. We'd ask that condition be dropped. With respect to the no contact order, there is a separate domestic violence protection order that has been ordered. That's under Superior Court case number 23-2-07634-06. Does currently protect the minor victim here in this case. And so with that said, then we would ask that the no contact order entered on this matter to incorporate that and follow it, meaning that there be language included in the no contact order that this no contact order would follow the conditions of the Superior Court protection order as it exists today or is later modified.
And Your Honor, the only reason the city is requesting we enter our standalone is that in civil protection orders, and I've confirmed it's the case in this particular civil protection order, when minor children are involved in civil protection orders that can only last 1 year, should this case play out beyond a year, that could potentially be terminated. Ours in a criminal matter can extend for 5 years, which is what I have requested in ours. So I would ask for a separate standalone criminal NCO.
And just to be clear, Your Honor, I think that as the case goes on, if there's an agreed modification on the protection order, for example, if we request supervised visitation or electronic communication, we'd ask for this to automatically be modified as that case is modified. And so I think that we'll be resolving this within the year. We don't object to the standalone no contact order. We just ask for it to follow the other protection order. I do agree with, I understand Ms. Carmi's point. I think that this case will resolve within the year. So.
And the city obviously is open to working with you should that be modified. I don't think the city would have a strong argument against modification in ours. I just don't want language saying ours automatically tracks theirs.
And Your Honor, the last note I would make is there were letters from Starting Point that were provided in this case. I think it would have been more relevant to the stay case that she was in compliance with the treatment program. She actually completed it as of April 12th. And then there is a very positive letter that her treatment provider did write in this case. So with all those things said, Your Honor, we would just, again, ask for, the conditions as I stated.
Yeah, I think as much as we would intend our no contact order to be a living document that could evolve with whatever's happening in Superior Court, we can't even get probable cause statements sometimes from Superior Court, much less nuanced changes to protection orders that we can real time switch here. I think certainly Ms. Carmi is an accommodating enough prosecutor and her office that if there was substantive changes made to the protection order, we could real time within 5 or 6 days have that amendment or change made. I think that just relying on the fact that somehow this is going to be modified based on Superior Court might be unrealistic. So I am going to sign the standalone no contact order. I understand the city's perspective. Again, I'm not making any statements about how long I think the duration of the case may last, but I think that is a legitimate issue that's different from a minor with a order versus an adult with an order. So I am going to sign it. I am not going to track it right now with Superior Court. Again, for the reasons that I've stated, I just think it's an overly arduous burden that I don't trust the paperwork chain of flowing back and forth between the two.
Understood, Your Honor.
Again, there is not a request for random UAs. I'm not going to impose random UAs. The prohibition regarding contacting minors, I think, terminated at the end of the felony case. So it would only be, do we want to bring that back? I don't see a reason in particular with the feedback from law enforcement, so I'm not going to create that sort of issue. I have no reason to do so. So Ms. Pack, your conditions of release are as follows. You're to violate no laws. You're to appear at all mandatory court dates. Again, that next mandatory court date, May 25th, 2023. You're to notify the court of any change of address or phone number. You're not to consume or possess any alcohol or non-prescribed drugs while your case is pending. You are to participate, and it sounds like you do have on a Scram monitor right now. I am placing you on enhanced pretrial release. The only reason I am doing that is just to ensure that if that monitor were to be taken off or something were to happen, the court would have notice quickly about that. I have signed the standalone no contact order. I'm going to tell you, Ms. Pack, the same thing I talked to each person about. No contact orders are complicated. There's a lot of legal jargon is the word I'll use. So if there's something you don't understand or something you don't think, especially if you're trying to rectify two documents, the protection order from Superior Court and this, please use Mr. Johnson as a resource. Most attorneys are going to tell you that, discretion is the better part of valor. Don't just plunge in. Understand what's going on, make sure that he signs off on whatever steps you're trying to take as being allowed under both. We'd hate to have this thing snowball any further. Okay. All right. With that said, Ms. Carmi, Mr. Johnson, anything further on Ms. Pack's case?
Did I miss anything? No, I think that covers it for us.
All right. We'll be getting you some documents over by the door, Ms. Pack. Make sure you're staying in good contact with Mr. Johnson.
Thank you.
Thank you.
You like, happy to pause or roll into more cases?
Yeah, let's just do a couple more. I'm fighting.
Okay. Next case I have, Your Honor, is Juan Machado.
Okay.
And Your Honor, what I am handing forward is a joint motion in order for a stay.
Okay. Mr. Machado, if I could have you state your name and date of birth, please, for the record.
Juan Machado, 2/20/1991.
Mr. Machado, as you've heard me tell, I think at least one other person so far in our docket, these stays of proceedings I am not a party to. This is simply a contractual agreement between yourself and the city of Battleground. My job is to make sure that you understand the terms of this agreement. And then if you comply with the agreement, that they follow through with their portion, okay? So that said, I am going to walk you through the terms of the agreement. This is a 12-month stay of proceedings. There are some financial obligations as part of the stay. There's a $150 filing fee, a $150 supervision fee for a total cost of $300. You are to maintain a payment plan to make sure that that portion is paid. You are to complete an anger evaluation and any recommended treatment. You are to have no contact with Natasha. I'm betting it's supposed to say Ferguson, but it says, is it just Fergoso? Fergoso, okay, sorry. With Natasha Fergoso pursuant to the no contact order entered under Clark County cause number 19-1-02283-06 as now entered or later modified. You're not to have any new law violations. You're to appear at all future court dates. The charge which you are entering your stay on is a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. In entering this agreement, you are giving up some important rights. First of all, you're giving up your right to have a jury trial on this case. You understand that, right, sir? And are you in agreement with waiving or giving up that right? Okay. The second is that you are doing a waiver of your right to speedy trial. I have two questions about that. Do you understand what your right to speedy trial is? Okay. And are you in agreement to begin that right to speedy trial a year from today, April 13th, 2024? Okay, give us 90 days from that date if necessary to bring you to trial. There are electronic signatures on the docket. Did you electronically sign the stay agreement, Mr. Machado? Okay. We're going to set a return date, sir, for July 13th, 2023. At that time, we will be reviewing the anger evaluation and hopefully have you involved in the treatment program by then. Just taking a look at one more note here. Any questions at all of your attorney, Mr. Johnson, or of the court before I sign you into the stay? Okay. All right. So we'll see you back here in about 3 months, sir. Please make sure to get a copy of that evaluation if you can, and treatment notes filed with the court prior to that July court date, okay? All right, sir, we'll get you your paperwork. Good luck on your stay.
Stand over there. Yep. The next case, Your Honor, is Bradley Weathers. Okay. Going forward, and this will be an entry into deferred prosecution.
Sounds good.
You stack of papers.
Yeah, all right. So, Mr. Weathers, if I can have you state your name and date of birth, please, for the record.
Bradley Weathers, March 8th, 1989.
Okay. Mr. Weathers, you're entering a program today called deferred prosecution. There's two documents. There's what's called a petition and an order. You also provide a copy of your police report, evaluation, and treatment plan. Were you able to review the petition and the order before today's hearing with your attorney, Mr. Johnson?
Yes, Your Honor.
Need any additional time to talk to him about your case?
No, Your Honor.
Okay. You and I are going to go through the documents together to make sure you understand everything. I'm also going to just take a quick look at the evaluation and treatment plan to make sure that you qualify. So give me just a moment to do that. All right, Mr. Weathers does qualify. I do see a copy of the police report here that is attached. Okay. The petition and the order are both very similar, sir. One basically states that you understand your obligations. The other one kind of sets those obligations forward. So I'm going to focus a little bit more on the second, which is the order. It has a little bit more of the substantive pieces of information. First of all, it states that the only person who can enter a deferred prosecution is a person who sincerely believes that they are suffer from alcoholism and that there's a high likelihood that they're going to engage in that conduct in the future. It also can only be entered by a person who believes that they are not innocent of the charge, that they are guilty of the crime that they're setting forth here in this circumstance, DUI. You're agreeing to undertake and carry out the requirements set forth in your evaluation and treatment plan. The court is going to monitor that you're able to do that. This is one of the most unique courts in Clark County because the judge actually monitors that, not a probation officer. So I get to see you as you make your way through the process. As you saw from some of the folks that are being reviewed today, I am the biggest cheerleader for doing the things you're supposed to do. And that's my favorite thing to have happen. In particular, for going forward with Starting Point, they are great about providing us documentation. So the hope is that we just cheer you through this whole process over this next few years. There are some financial costs, sir. There's a $250 breath test fee, a $200 emergency response fee. There is a monitoring fee that totals $1,000 during the 2 years that you're being monitored. There is a $150 filing fee and a $250 administrative costs. That's to be paid at $100 a month, beginning 30 days after you formally enter. You are to complete a victims panel if you have not already. The specific findings that the court is going to enter here is that on December 11th, 2022, you were charged with DUI refusal and driving while suspended in the 3rd degree. The box isn't checked, but I'm going to check the substance use disorder box simply because that was what the valuation that I looked at indicated.
Thank you, Judge.
Extensive and long-term treatment are required and available. You've stipulated to the admissibility and sufficiency of the police reports, meaning if we were to revoke this deferred prosecution, I would simply review those reports, determine if there was probable cause and making my finding of guilty. So you're agreeing that those statements and so forth in those reports are admissible. You're waiving your rights associated with trial, both to have a trial, a speedy trial, those sort of things in this case. If you fail to carry out the conditions of your treatment plan, the evaluation, or the other expectations of the court, we can hold a hearing to determine if you should stay on your deferred prosecution. That ultimately can lead to something called a Shattuck hearing. If the court takes your deferred away, some of the fees and costs you've paid can be put forward. It's not like you have to pay those fines and fees twice. Even if you complete a deferred prosecution, if in the 2 years following your deferred, so year 6 and year 7 in the process, you were to get another DUI, this charge still enhances, meaning it can make that charge have even a higher penalty even after it's dismissed. And that's one of the nuances that's in the petition that's important to understand. The court will notify the Department of Licensing that you've been entered into this deferred prosecution program. Upon successful completion of the program, again, a little bit of a unique thing here. Usually we have a court appearance right around that time where we dismiss, but if not, it is dismissal that takes place automatically, okay? With that said, Mr. Weathers, I know this is a lot of information. Are you prepared to go forward and enter the deferred prosecution today?
Yes, Your Honor.
Do you have any questions of Mr. Johnson or of the court before we do so?
No, Your Honor.
All right. I'm going to go ahead and sign you into the deferred prosecution program. We're going to set our first review date, Mr. Johnson, for the 13th of July, 2023.
Sounds good, Your Honor.
It's going to be at 1:30 p.m. Are you doing your treatment with Starting Point?
Yes, Your Honor.
They're usually really good if you let them know that future court date of sending a kind of a progress letter, usually a week or two before, which is really helpful for me to kind of gauge where someone is before the hearing today. Okay. All righty. It looks to me like all the documents are proper and ready to go. Mr. Weathers, we're going to get you some copies of the documents. I wish you absolutely well, and I'll see you this summer a little bit later, okay?
Thank you, Your Honor.
All right. Good luck, sir.
Judge, there'd just be one last thing to address real quick.
Is it on Mr. Weathers or something else?
It is on Mr. Weathers.
Okay.
So hold on just a second, Your Honor. He was, and we could maybe, I don't know if the court prefers to handle this off docket, but we had an agreement with the city. He was simultaneously cited for infractions on that date. So he was cited under the case numbers 2A0712-994. So there's 3 infractions. The agreement with the city would be for the city to dismiss count 1 and 3, and then he would be admitting to count 2.
Okay, so I'm looking at the face of the infraction. I have 1 being failure to drive on the right side of the road. I have 3 operating a motor vehicle without insurance. Those 2 are going to be dismissed.
That'd be correct, Your Honor.
Okay. And that 2, which is move unsafe vehicle or vehicle with defective equipment infraction, is the one that would be agreed
He'd
to
be
be
admitting to.
committed. Okay. Okay, Mr. Weathers, so we have on this matter a finding on just one of those cases today pursuant to the agreement that was entered. Noting a total cost of $139. And we'll give you some paperwork on also how to get that infraction taken care of, okay? All right, sir, good luck.
That covers it, Your Honor. Thank you.
Yes, driving while suspended is on the deferred prosecution.
Thank
Thank
you,
you for
Judge.
asking, Ms. Travers. Good luck, Mr. Weathers.
Thank you, Your Honor.
Kenneth Lowe. Good afternoon, sir. And it looks like Mr. Lowe was representing himself. Have you had a chance to talk to Ms. Carmi about your case at all, sir?
No, I actually really need an attorney.
You actually what?
I need an attorney.
Okay,
You would like to be this.
okay, that's fine. We can certainly assign you and screen you today. I'm gonna ask you some questions about your income to determine if you qualify. Do you receive any manner of state assistance at all, sir?
No,
Are you employed right now?
yeah,
Can you estimate about how much you earn every month after taxes?
right about 2,000.
Do you have any dependents at all?
No,
So the state says that the guideline for a person with no dependents is $1,500. So you're $500 over the guidelines. So I can't go that far outside of the guidelines to assign you an attorney today. I can certainly give you some additional time if you want to try to retain an attorney.
I guess, I don't know, because I don't know how I'm gonna retain one. I can't afford that.
Okay, let's talk a
With
little bit
today's
about,
inflation, all my money's gone at the end of the month. I'm lucky if I got $50.
okay. Do you have some outstanding debt and so forth that you're handling
Well,
right now?
No, but I do have like medications I gotta get for epilepsy and that takes my money. And then my rent, that's,
All right, I think in light of that outstanding debt and so forth, I can go ahead and appoint you an attorney. Sounds like it would assist you. Court will assign,
Mr. Campbell.
okay, court's going to assign Brandon Campbell. I'm just going to see where we are on speedy trial, sir. So right now. So your initial arraignment was back on March 2nd. So we're about 45 days into your speedy trial. We just assigned an attorney, but that will not restart that speedy trial. So.
And your Honor, this is Brandon Campbell.
Hi, Brandon.
If you could give the client my cell phone number, he can step out and call me. I will also be in court personally in about 10 minutes. So either way, I think it would be prudent for me to discuss with this client his speedy trial rights and potentially, if it's prudent and the client believes that's in his best interest, waive those rights. But I just need to briefly speak with him.
So I'm going to have Mr. Campbell talk to you before you come back up in front of me. So if you want to have a seat, I'll get him your file. Okay.
okay.
Thank you, sir. Okay, sounds good. When Brandon comes out, Jacob just comes out. Yeah, thank you. Okay.
Yeah.
All right. I have Tyler Capps here. Mary McCaffrey. Okay. Good afternoon, Ms. McCaffrey. I could have you just state your name and date of birth, please, for the record.
Mary McCaffrey, 6/12/85.
Okay. I'm just pulling up your paperwork, Ms. McCaffrey. Give me just a minute, please. All right, so it looks like I last saw you in January. You were assigned 80 hours of community service, victims panel, substance abuse evaluation, and 8-hour class. That has been completed. You had 25 hours of community service completed in January. You have some additional paperwork for me today?
No, it's still at Furry Friends.
Okay.
I've
How
not-
much do you have done now?
How much I've done? I have about 50.
You're at 50 hours
Yeah.
now? So you have 30 hours remaining?
Yeah, I have been working a whole lot. I did bring my paycheck stubs if you wanted to see those. Just working nights and working the weekends. It's been really hard to get any more hours in.
Okay. So what we're gonna do, I'm gonna set this out 2 months, but I actually need some paperwork from them next time, okay? So I'm saying right now you have 50 hours done. My hope is to see 60 or 70 hours in 2 months, just to be candid. So we're gonna set you out, Ms. McCaffrey, to does June 8th work for you?
Yeah.
Okay, see you, set you out to June 8th. 6/8/23. We'll get you a copy of that return to court form. Uh-oh. You did.
Oh, so sorry.
You're like a gunfighter, Carol. So I just saved it. You can print it now and we'll get you by the door. Thanks, Ms. McCaffrey. Go ahead, ma'am.
I did get a speeding ticket. I just
Okay.
wanted to say that.
That's fine. So certainly a new criminal charge would be very problematic. A speeding ticket, while unfortunate and costly, won't impact anything on this case.
Okay.
Thank you, ma'am. I appreciate your candor. We'll get you some paperwork by the door. Is Nicole McDonald here? I can't see the Zoom waiting room, so I don't know. Let me. I click on participants. I do see that. I can see everyone that's in. I can't see anyone in a waiting room. I promise. I can't see them. Okay. Is Sasha McGuire here? All right, Ms. McGuire, why don't you come forward, ma'am? Good afternoon, ma'am. Can you state your name and date of birth, please, for the record?
Sasha McGuire, 6/26/1990.
All right. So Ms. McGuire, I assigned you 48 hours of community service back in January. Do you have your paperwork with you?
I was wondering if I could have some more time on it.
How much do you have done?
I only have like 10 hours,
Where are you doing it?
but I've been, well, I'm Habitat for Humanity and I've been taking care of my mother-in-law. That's why I haven't gotten it like done all the way.
Okay. So you have completed 10 hours?
Yeah.
So there's kind of two things I do in these sort of circumstances. You got no paperwork. Is either I convert it to work crew
Mhm.
or I set it out 2 months and give you a last chance, but you need to have documents next time
Okay.
and a significant amount of your community service done.
Okay.
Can you do that?
Yes, I'll have it done by, yeah.
All right. We'll have ACS completed by next court date. Okay, so I'm gonna give you the benefit of the doubt, that 2-month time frame. So today's the 13th of April. We'll set this out to the 15th of June.
Okay.
Please, you can always get that document to us early. Bring it with you. If not, I'm gonna have to convert it to something harder. So please get it done. Okay.
Okay.
We'll get you some paperwork by the door. Once you have it, you are free to go. Thank you. Ms. McDonald is still connecting. Timothy McKinney here. Ms. West, I guess, was also in the waiting room. We try to bring Ms. Oh, we already did. Thank you. Ms. West, if I could have you turn your camera on, please, ma'am.
Can you hear me?
I can hear you. Can you turn your camera on, please?
I'm trying, just a minute. I haven't used this computer before, so just a second.
Sounds good.
All right, there I am. Hi,
Thank you. Hello, can you state your name and date of birth, please, for the record?
Rochelle West, 12/16/1985.
Okay. So I'm just gonna pull your paperwork up, Ms. West. Give me just a minute, please. All right, so where we are, you were last in court back on the 12th of January. You completed your community service. We have documentation that your anger evaluation was scheduled, but nothing else received. So what's going on in that anger evaluation and treatment?
So the anger evaluation has been really rough for me to like pay for. I just paid $6,400 to move into my new place, and it's been just really, really rough. Like getting back into the realm of things has been just one little bit of a obstacle after another. And so having to pay for it, they're asking for like $1,000 over here in Portland. I don't know if it's different in Washington, and maybe that would make a difference if I went there and did it. But that's something I can look into.
So how long is it going to take to have that component started?
I could probably at least get everything started and paid for by, I'd say about May, end of May. I've already been putting like $50 away every paycheck. So I mean, I've been doing the best I can. So by the end of May, I should be able to have it.
All right, I'm going to set this out to mid-June, Ms. West.
Okay.
I'm going to hold you to that time frame, okay?
Thank you, Your Honor. I appreciate it.
So I have noted on here that you will have completed your evaluation and be in treatment by your next court date if treatment's recommended, okay?
Okay, great.
So you mentioned moving. Are you not on 92nd Avenue in Portland anymore?
No, I'm not. I'm actually at, you want me to give you the address right now?
Are you comfortable with giving your address over Zoom or over YouTube?
Yeah, it's on YouTube.
Yeah, we stream on YouTube. I don't know how many people watch it, but we're on YouTube.
Okay.
So you can also, if you want to, put it in the chat
Okay.
to one of our clerks, and we can do it that way if that's more comfortable.
Yeah, I'm gonna start a chat right now.
All right, you start that chat. We'll get the documents sent to you. I need to see those documents by the 14th of June. Okay, Ms. West?
Okay, sounds good.
Thank you. Have a good day.
You too, Your Honor. Thanks.
15th of June.
Yeah, it says the 14th. Do you want to correct that for me?
We can come in on Wednesday.
I'm calendar challenged, apparently. Phone dialing and calendars. Yikes.
It's
Ms.
okay.
McDonald, can you hear me, ma'am? Nicole McDonald?
Your Honor, I have 2 pro ses that are ready
Okay.
whenever you're ready.
Ms. McDonald, can you hear the court, ma'am?
I can. Can you hear me?
I can. Can you turn your camera on, please, ma'am?
Yes, sir.
Thank you.
There you go. Sorry, I'm not very techno savvy. I apologize.
It's okay. Can you state your name and date of birth, please, for the record?
Nicole McDonald, April 17th, 1985.
Thank you, Ms. McDonald. You're before the court for review. Let me get your paperwork pulled up.
Yes, sir.
All right, Ms. McDonald, it looks to me like you were assigned. Looks like we converted your 7 days of work crew to 42 hours of community service. We also had, it's like the DV evaluation and treatment and the mental health evaluation. So I guess we'll do the first thing first. Have you done your community service?
I have not, Your Honor.
Okay. Can you tell me why?
My mother fell ill, so I've been back and forth between Bremerton and here for the last couple months, but she's better now and I'm here now in Vancouver. But I have set up a meeting for my evaluation. Two out of the 3 places I was given for the DV evaluation, 2 of them are no longer taking females or not doing them at all. So I have a meeting with the last place.
So right now, Ms. McDonald, you've been on a stay in our court for 7 months. And as far as I can tell, you haven't done anything.
I'm in the process of doing them, Your Honor. I have contacted places and I have appointments coming up to get my DV and my mental evaluation done.
So at this point, I'm assuming that you're going to have your stay revoked, but I'll defer to Ms. Carmi. Go ahead.
Yeah, I think at this point, Your Honor, I'd like to set a 2-week set out. The city will be moving and is moving orally to revoke the stay. We will file the formal paperwork. When we entered this stay, it was under the assumption that there would be a full 12 months of mental health and DV treatment. We're halfway through, which means even if it happened tomorrow, there'd be 6 months of treatment, and that was not the agreement.
I wasn't aware that it was going to be.
All right, Ms. McDonald, we're going to have a court date for you, ma'am, on the 27th of April. Are you still on U Street in Vancouver?
That is my brother's address, and I'm just using that because I'm between homes. And I have been.
Okay. I would like you to be in person, ma'am, because we're having issues with your connection. So I need you to be here on April 27th in person at 1:30. Do you understand?
Yes, sir.
All right, Ms. McDonald, we will see you then. Thank you, ma'am. Okay.
On our road stage, let me know how you want to handle this. We have 3.
Okay.
I know Your Honor took care of one and I asked them, so thank you. One is Jason Holmes, which I believe he is going to be requesting more time to be comfortable.
All right, Mr. Combs here. Come on up, sir. Here to the rostrum, please. If I could have you just state your name and date of birth, please, for the record, sir.
Jason Combs, December 11th, 1999.
Okay. So, Mr. Combs, it looks to me, or it sounds like from what the city attorney is stating, that you're going to be requesting some additional time to hire an attorney.
Yes, sir. Seems so.
What does that mean?
I kind of have some questions.
I guess to put it in perspective, Your Honor, we did make a plea offer. We emailed him the paperwork. He came here today saying he has questions about that paperwork. So given his questions, I wouldn't be comfortable having him enter the plea. So then we discussed that he does have the right to review it, and that's what he told us he wanted to do.
Okay, that's fine. I can't give you any legal advice.
Yeah.
So, but I understand if you have, would like someone to look at it, make sure it's fine. I have no problem with that.
Thank you.
We did discuss the city when we were requesting a waiver. I think that arrangement was March 2nd.
It depends on how much time you need. So certainly from the first time you went to court on March 2nd, you brought to trial within 90 days. So that means your speedy trial time ends at the beginning of June. So if you wanted like 2 weeks, I'd be inclined to set it over without a waiver. If we need any more time, we're probably going to need you to have you do a waiver to allow a future court date to happen.
Okay. 2 weeks.
2 weeks? Okay. All right, so we're going to set Mr. Combs over. Please make sure you've kind of taken those next steps by that time, or we're going to be in the exact same boat that we're in today. So 2 weeks takes us to the 27th. That's going to be on our 2 p.m. docket, sir. Conditions of release, including no driving without a valid license, remain. I am going to note that you are continuing as pro se right now. Hopefully you get those questions answered and we're able to kind of move this forward at your next date. We'll get you some paperwork over by the door. Once you have it, you are free to go. Good luck, sir. Thank you.
And then, Your Honor, depending on how you want to handle this contested, I'll just let you know the other 2 pro ses, one will be a change of plea and one will be entering the stay.
Okay, so our contested hearings are scheduled for 3. I do see, I know Sergeant Knuth I saw was on, and I knew there's another law enforcement officer here present. Let's see who is here for the contested hearing. Yeah. Is Irwinjit Singh here?
Oh, Thank you. Yes, Mr. Johnson indicated he was going to be returning to his office to zoom in for that.
How about Manuel Gutierrez? Manuel Gutierrez. Joseph Burris.
And he is one. He is one where an officer will not be present for today.
Okay, and looks like Lynn Warren.
And I don't see anyone else online.
Anyone sees any of these folks in the waiting room, I'm fine with bringing them in.
Okay.
We're gonna we have some morning people. Mr. Campbell, are you ready to go on some of your people that have been here since?
So I would appreciate it if we could call those 2 matters from the morning.
Yeah, let's get those going. Those people have been here for a long
So
time.
if we could have Logan Holland come forward.
Okay.
So Your Honor, Mr. Holland has engaged in treatment and is prepared to enter a deferred prosecution today. And just as a matter of discussing the current platform of the charges, he was originally charged with a DUI of 1.15. There were some colorable, I'll call them meaty search issues in this case. And as a principle of that, discussions on the pretrial motions, the deferred is going to be entered on an orally amended charge of reckless driving. So he's going to enter a deferred as a substance use disorder on the reckless driving reduction from the original charge of DUI, if that makes sense. Which I believe he can.
I mean, he can.
He's got an
Does he strategically want to do that?
He's got an outstanding DUI at Callis. It's gone probation.
But if it's amended to reckless, it doesn't have any of the mandatory minimums.
Well, and that's correct. We've discussed that. And my concern is just that in investigating the likelihood of his doing jail on a sanction up there on a non-mandatory probation violation, he would like to pay the extra amount of money to do the deferred to avoid that complication.
All right, so let me just make sure I understand, and I promise I'll get there in a minute. So the DUI charge is being amended to reckless driving.
Correct.
The intention is to enter a deferred prosecution on a reckless driving.
Correct.
And the reason for doing that was that you felt like, because the court can still find a probation violation on a preponderance standard, even if you do a deferred prosecution.
That is correct. However, just logistically, I think even with the deferred being entered in, my understanding is that Callis would have to, on a denial of a violation, because he hasn't been convicted of anything yet, they would have to bring up a contested hearing and have the officers actually travel to Callis for that PV hearing, which I am of the opinion that they will not do. So we think it will avoid a PV violation in Callis for him to enter this deferred on the reckless is my belief. It may not. He is aware that it may not.
Is there not a breath test?
There is a breath test certificate in this case. That's true.
They could just enter that and find on the preponderance consumption, but.
Well,
I'm just saying that because this is something, at least the way it is statutorily right now, that he can deploy only one time.
I think he can actually continue to deploy the deferred if it's not on an underlying charge for DUI. So the prohibition on the deferred, is that not accurate?
It's not accurate. Right, the way that the law is written right now is he can enter a deferred prosecution one time. It doesn't stipulate on what he's entering it on. I think the only caveat to that might be a domestic violence deferred prosecution and then deploying it on it. But if you can't do it on 2 alcohol related offenses, at least is my understanding right now. Now, granted, reckless in itself is not a per se alcohol related offense.
Your Honor, maybe we could recall this matter. We can go through the Clifton Brown matter and I can briefly review the statute to see, because that may impact the client's decision.
All right, let's just make sure, because spider sense tingling on that one. Right. Okay.
Did you just do a Spider-Man?
I did.
Let me look at the statute. And then we can call the Clifton Brown matter, Your Honor.
Okay. Mr. Brown. All right, Mr. Brown. Looks like we're doing a little bit of a couple of things, Mr. Brown. We're doing a plea today and we're doing a stay. Is that your understanding?
That was the contractual agreement that ends after 2 years and then your cases are dismissed.
Okay, yes, sir.
Okay, do we have plenty of time to talk to Mr. Campbell today?
Yes, I do.
Need any additional time?
No, sir.
All right. I'm gonna go over the stay with you first, and then we're gonna go do your plea, okay? So, as you've heard me tell the other people that have appeared in front of me, a stay is a contract between yourself and the city of Battleground. I'm not a party to it. I'm simply gonna let you know the things that you have to do while you're on the stay.
Yes, sir.
And if you follow through with those things at the end, the case gets dismissed after 2 years, okay? You have some costs on your stay. There's a filing fee of $300, a supervision fee of $150, and a public defender recoupment of $600. So a total financial obligation of $1,050 that you're going to pay over a 2-year time frame. Okay. Do your best, enter a payment plan with the court that you think is going to be something that you can satisfy. I know that there's some financial issues and such. My hope is that with the VA, hopefully maybe some of that gets straightened out. You are to do a substance abuse evaluation and complete any recommended treatment. You are also to do a DV evaluation and comply with treatment. You're to provide the police reports to those treatment agencies. You're not to have any contact with Eileen Middleton. You're not to have any new criminal charges. You're to appear at all your future court dates, and you're to complete the victim's impact panel. Do you have any questions about any of those conditions, sir?
No, sir.
Okay. The charges which you are entering your stay on are both what are called gross misdemeanors. They are both subject to 364 days in jail and a $5,000 fine. On both those cases, you're giving up some important rights, including your right to a speedy and public trial. Do you understand what your right to a speedy trial is?
Yes, sir.
And do you understand that you're going to be doing a waiver starting April 23rd, 2020? I think it should be 2025, Mr. Campbell, because it's a 2-year stay.
You're correct, sir.
All right, I'm going to just strike that. And are you in agreement with that, Mr. Brown?
Yes, sir.
You're also giving up your right to go to trial, meaning you couldn't come back and later say that you wanted to have a trial, call witnesses, those sort of things. Are you in agreement with that?
Yes, sir.
Okay. Is this your signature, sir, on the final page here?
Yes, sir.
Okay. Do you have any questions of the court or of your attorney, Mr. Campbell, before we sign you into the stay agreement?
No, sir.
Okay.
And Your Honor, the city just wanted to put on the record in this case, because they're both DV allegations. It's somewhat unusual to enter stays for those, that the victim has been notified that she's in full support of this. And so the city just wants to make that clear, should any questions come up down the road.
All right, thank you, Ms. Carmi. So, Mr. Brown, we're going to do a review hearing for you on July 13th. At that time, we're going to make sure that you've gotten your substance abuse disorder evaluation. We're also going to make sure, hopefully, you've gotten involved in some manner of the DV treatment. That is a required court date, again, July 13th, 2023 at 1:30. Our final court date is going to be April 10th, 2025 at 1:30 p.m. At that time, if you've completed your conditions, we'll be dismissing both these charges. Do you have any questions at all, sir?
No.
All right, I'm going to be signing the paperwork to enter you into the stay agreement right now. Yes, the two cause numbers we're entering the stay on are 3A0 276-535, or maybe it's 935, sorry, and 3A0252948. Thank you. Okay. All right, we also have before the court then the DUI charge is being amended to negligent driving in the first degree. Have you been able to talk to Mr. Campbell about that charge, sir, in the resolution of that case today?
Yes, I have.
Okay, you need any additional time?
No.
All right, I'm gonna go through your plea paperwork with you. If you need some time while we're going through it, get my attention and I'll let you talk to Mr. Campbell some more. You're Clifton Brown, you're 58 and you've completed the 12th grade of school. Is that correct?
Correct.
You able to read and understand the English language?
Yes, sir.
On your DUI case, you're giving up some important rights today. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you. And these witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights?
Yeah, sure.
You understand that in your plea today, you're waiving or giving up those rights. The charge which you are entering or your plea on is what is called a simple misdemeanor, negligent driving in the first degree, subject to 90 days in jail and a $1,000 fine. I am holding up a pretrial agreement. You understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law.
Yes.
Okay. The court can have you pay cost, fees, and assessments as authorized by law during your 2-year probation period. To the charge of negligent driving in the first degree taking place on February 17th, 2023 in the city of Battleground, how do you plead?
Guilty.
Are you entering this plea freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty?
Yes, sir.
Factual basis states on or about February 17, 2023 in Battleground, Washington, I operated a motor vehicle negligently, risking damage to property, showing the effects of having consumed alcohol. Is that a correct statement, sir?
Yes, sir.
It looks like the incident took place on the 16th,
What's the date that I put, Your Honor?
17th.
I apologize for that. That's my mistake then. I'd have to.
All right, so I'm just gonna amend that to say the 16th, Mr. Brown. Are you
Yes.
in agreement with that?
I am.
Okay. I will accept the plea, find it knowing, intelligently, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Mr. Brown, is I'm going to hear from the city attorney, Ms. Carmy. I'm going to hear from your attorney, Mr. Campbell. And if you choose to speak, you have the right to address the court. Go ahead, Ms. Carmy.
Yes, Your Honor, we would ask the court to follow the recommendations. It was heavily negotiated globally with the stay. It is a credit time served offer, given the time he's already served in this case. We would also note, and I believe this is clear in the paperwork, that the substance abuse evaluation and treatment under this plea will also concurrently work for the substance abuse evaluation and treatment done under the stay.
Mr. Campbell.
Your Honor, I just firstly would like to express Mr. Brown's appreciation for the gracious way in which you allowed him to be out of custody in order to resolve this matter. He has obtained housing. He's made some contact with individuals with the VA. I'm not sure if they helped him with the housing or exactly how that occurred, but he's aware of the resources in the community and understands what he needs to do in order to comply with the terms of this agreement. He's been out on the BART without any violation reports I'm aware of since he was released from custody 2 weeks ago. A week ago. 2 weeks. 2 weeks ago. And so this is a situation where Mr. Brown, I think, was in pretty well dire straits. The first time he came here was in even more dire straits. The second time he came here and has stabilized himself to an extent. I know that he has a grave aversion to going back to the Clark County Jail. So I expect, he's going to get these things done that he has to be getting done for the court. He's aware of what he needs to do. He's a wise man in many ways. And I expect he'll be back in compliance the next time he sees Your Honor. And so, Mr. Brown, you can talk to the judge if you'd like, or you have no duty to speak to him if you don't wish to.
I'm okay, brother. I'm okay. Thank you.
I remember, Mr. Brown, you were in a rough spot when we first had to take you in. You were in a little bit of a rougher spot when we saw you in jail. So I'm glad. I think that the city did a great job of working to get that BART device paid for to get you out of custody. I'm ecstatic that you're not living in your car right now.
Yeah.
I mean, able to get your car back.
Somebody stole it.
Uh-oh. That's not good.
It's not good.
No.
Well, And that's unfortunate, but even the city even went so far as to contact me that his vehicle was still here and at some point, so I'm, it's too bad that that's occurred, but did you file a police report on that? Yeah. Okay. Oh, okay. No. Really? Correct. Okay.
So, Mr. Brown, I am going to be following the agreement. So certainly it is going to be 90 days in custody with 83 days suspended, 7 days to serve, credit time served for 7 days. I'm not going to go back to the jail. It's in your hands now, though. So behave yourself. I am going to find that Mr. Brown is indigent, in particular with some of the costs and fees on his stay. I'm not going to impose any costs or fees on this case. So it's $1,000 with 1,000 suspended. And as Ms. Carmi stated, the alcohol evaluation victims panel on the stay and on this case, same thing. You only have to do it one time, sir. Bench probation, 24 months. We're going to have the same review date on both cases. Mr. Brown, for the 13th of July, 2023 at 1:30 in the afternoon, looking at that substance abuse evaluation and victims panel. I wish you well, sir.
Thank you. And Your Honor, just quickly, did the paperwork on the stay note, the pretrial NCO remains in place for the 2 years?
It does have the part check that says
It
formal
does.
no contact order. I didn't think we had to do anything else because there was already a pretrial order done. I didn't put it in the
Perfect.
court and the prosecutor.
So I don't know if the court needs anything further. I think Carol wanted to double verify that.
Needed to verify that the NCO was staying in place.
It
Yeah.
is staying in place by agreement of the parties.
Thank you.
I'm trying to think, oh, and the pretrial release BART monitor, you can get that removed as of today.
Okay.
You're gonna get some paperwork to get that off.
Thank
Okay.
you very much.
All right, thank you, Mr. Brown. Good luck, sir. Wish you well.
Your Honor, can we ask Sergeant if he is waiting test period?
Sergeant, can you tell us which contested matter you were waiting on, sir?
It is the Lynn Warren case.
Okay, so Ms. Cameron did send an email to Gail down at PD. That's going to be set over, so we don't need Sergeant Knut on to write down. So the hearing.
All right, sounds like the hearing was set over. Sergeant Knuth, I wasn't a part of that, so do we have a new date we can give the sergeant for that, Ms. Landwehr?
I do not, probably at least 2 or 3 weeks out.
Sounds good. We'll send you the appropriate notice, Sergeant. We appreciate your time today, sir.
Thank you, Your Honor. Take care.
All right.
Here I have 3 matters potentially. Kylie Bernard, I believe, was coming in this afternoon, but I don't know if he's appeared.
Kylie Bernard is now in the courtroom. Mr. Campbell, though, is dealing with other matters. So.
And then there were 2 reviews that I wanted to provide input on. Dylan
Right.
Hamilton and Dalton Blank.
Okay, so Mr. Blank, I see him. Come forward, Mr. Blank.
I'm gonna check with Mr. Campbell if he could take Kylie Bernard.
Is there a reason that I don't have Dalton Blank's file? I recognize Mr. Blank. Oh, got it right here. Sorry, Mr. Blank. Fine. Okay, can you state your name and date of birth, please, for the record?
Dalton Blank, 030792.
Okay, so Mr. Busby is present on Mr. Blank's case, and she paperwork pulled up, sir. All right, Mr. Blank. Looks to me like you were assigned 30 hours of community service, which you completed. Your mental health assessment has been received.
I also have my certificate that we needed.
Certificate for what?
This certificate of completion that we also needed.
Okay. It says decline treatment, but does qualify for treatment, still awaiting treatment paperwork from Community Services Northwest. I think what we were awaiting for then, Mr. Blank, was a copy of your evaluation and treatment plan. That's just a graduation form, it looks like.
So when we talked last time, I just got out, I just completed treatment and part of the thing is saying.
So because he's on Zoom, he can't hear you unless you're by that microphone. So I can certainly hear you, but the prosecutor needs to hear you too, okay? So go ahead.
So what we agreed upon was that, during this, when this case is going on, I was in drug and alcohol treatment. And you said that and I completed it. So you said I didn't have to do evaluation for that. As long as I could bring in my certificate of completion.
Okay.
And then I had to do the evaluation. And everything else.
I'm just looking at one thing, Mr. Blank. I'm gonna just take a look at one piece of paper here. Give me a sec. So, Mr. Busby, just to let you know, I do have something from CMAR that shows that Mr. Blank graduated from their intensive outpatient and outpatient alcohol and drug program as of June 16th, 2022.
Okay.
So wanted you to be aware of that. I also do have, he has completed his community service and he does have a mental health evaluation on file. So go ahead with what you want to say.
Yes, Your Honor, and my concern, the city's concern is the mental health evaluation didn't recommend no treatment. It recommended treatment and noted that Mr. Blank was refusing treatment. The stay requires him to participate in that treatment. So if he does not wish to participate, the city would be moving to revoke the stay.
So she didn't tell me anything about having to do any treatment. She just asked if I would like to do treatment or if there's any further thing that they could help me with. And I said, no, I don't think I need anything else because I was in treatment with them before. And the same thing was kind of brought up that the counselor there had she couldn't really see why I had to see her every week. She thought it was kind of pointless, I guess.
So is one of the things, Mr. Blank, that we talked to you about when we first put you on the stay is we said the stay is a contract. And so when I say a contract, I'm not party to that contract. The person that you have to satisfy in that contract is the prosecutor.
Right.
And I'll agree that what the prosecutor is saying here is that you got an evaluation that says that I can't, because it's a medical document, I can't say what it says, but it says that they do find that you have an issue that they can assist you with, but you are choosing not to do the treatment or declining treatment or whatever else.
So nobody told me that that's what they wanted me to do.
Okay, so
from
what
my understanding, she was making it seem.
So what I'm telling you now is, though, it sounds to me like, and the city can correct me if I'm wrong, that if you do qualify for treatment, they want you to participate in treatment. Is that fair to say, Mr. Busby?
That's correct, Your Honor. And I read through this evaluation pretty in depth, and I haven't filed a motion to revoke the stay at this point because I did want to give Mr. Blank the opportunity to make a decision and know that that's what the city is basing its position on, is essentially this treatment evaluation did indicate that services are recommended. And there was some inconsistencies between presentation in, I believe it was December of this year. No, just this past month, March and February of last year. And there were some significant concerns raised by the evaluator based on that. And so there were recommendations for treatment. I understand Mr. Blank's indication is that they were simply asking him if he wanted to have a referral. The city's position is that they're recommending it. That is specified in the treatment recommendations is individual therapy.
So Mr. Blank, what's going to happen is, it sounds to me like they'd like you to participate in the treatment program. I'm going to give you until the 22nd of June to get involved in the treatment program and get documentation to the court, okay?
So my thing is, like, they never gave me the same, they didn't recommend.
So you and I are not arguing on this?
No, I'm just curious.
He's telling you
how to go about it, because they didn't tell me they wanted me to do this.
So I'd contact the provider. So you did your evaluation with CMAR.
Like, they didn't give me paperwork in my left, right?
You have paperwork. You can go back in there and they can provide you your paperwork.
Yeah.
So you need to engage with them though, okay? I'm going to find that you are compliant on the substance abuse evaluation and treatment. On the mental health evaluation, I am finding that has been completed. And the mental health treatment. I'm finding non-compliant right now, but again, as soon as you get that part taken care of, they can engage with you for 3 weeks, 4 weeks, 10 weeks, whatever they think necessary. I'm not going to control that, but simply that it looks like you do need to engage based on the evaluation. Do you understand?
Yeah, I just was under a different.
I'm not saying you weren't. I'm just trying to explain. I want you to keep on your stay, okay?
Yep.
All right, Mr. Blank, we'll get some paperwork by the door. Thank you, sir. All right, good luck, sir. One other document, Jacob, sorry, that was on Mr. Blank's case, goes in that file. All right, I'm gonna call the rest of the contested hearings so we can get our officers on their way. So it sounds like Lynn Warren got set over. Someone can see if these folks are on Zoom. I can't see the Zoom waiting room. Okay,
Joe Burris is, he's the only one without an officer here.
all right, and so Officer Seifert is here. Okay, thank you, sir. He's here on the Manuel Gortarez case. I am going to find that this matter was scheduled for a contested hearing at 3 p.m. It is now 3, or is it 2:30 that contested?
3 o'clock.
3 o'clock. We have officers here present. They are not best serving our community, waiting in court for folks to show up that are late. So right now I'm going to find that those infractions have been committed by Mr. Gortarez's non-appearance. I'm going to assess the speeding too fast for conditions fine of $145. I'm going to assess the failure to renew or have an expired registration for $237 for a total financial cost of $382. Certainly, I think it's folks' responsibility. They're absolutely able to request these contested hearings, but in particular, if we have law enforcement showing up, folks need to be present on time and ready to go. None of us are better suited by our law enforcement staying with us here in the courtroom. All right. We also have Officer, is it Debiak? All right, Officer Debiak here on the Irwinjit Singh matter, and I don't see Mr. Mr. Johnson is here. Mr. Johnson?
Yes, Judge, good afternoon. I am here.
Good afternoon. So we have the officer present in the courtroom. Are you ready to proceed on Mr. Singh?
I am, Your Honor, and I apologize. I didn't realize the officer would be present, but what I just received very recently was permission from my client, or authority, I should say, to seek a deferred finding on the matter. And so did recently receive confirmation that he was eligible.
Is he not?
I'm told that he is not eligible, but I see the CDL box is checked no, but I also have a notation here that he has a CDL. Are you aware of your client having a commercial driver's license, Mr. Johnson?
Your Honor, I'm confused by that. I don't know that to be the true, or I don't know that to be the case for certain, no.
Okay. So let me just make sure I can cut to the chase. So you're requesting a deferred finding if we are to determine that he does not have a CDL?
Your Honor, if you find him to be eligible to defer it, he'd only be eligible if he doesn't have a CDL. If he does have a CDL, then I don't think he's eligible. And then, I guess then we can proceed accordingly.
Do you want to give him a call or somehow do some research? Ms. Travers is generally pretty good with our friends at the DOL. Do you want to call and verify with your client if he has a CDL or not?
Yes, Your Honor, we can do that. Thank you.
All right, sounds good. We'll recall this matter when Mr. Johnson is ready. Please. One, at least know what we're looking at. Thank you. Can we bring in Mr. Burris then, who's the other contested hearing? Officer, hopefully we're not going to keep you here much longer. This whole day has been kind of us dragging our anchor behind us a little bit.
Oh, it's been great.
Mr. Burris, if I could have you turn your camera on, sir, when you're ready.
Yes, sir.
Thank you, sir. Can I have you state your name and date of birth, please, for the record?
My name is Joe Burris, and my date of birth is 11/12/79.
All right, so Mr. Burris, you have requested a contested hearing. I generally go over with all folks who request a contested hearing their other options, simply not because I'm directing you what to do, but simply because I want folks to understand all the options. Your first option is you are eligible for what is called a deferred finding. If we did a deferred finding, what that would mean was that you would pay a fee of $150. Your case then, if you did not have another moving violation in the next 12 months, at the conclusion of that 12-month period would be dismissed. It's the best way for a lot of folks to keep this from going on their drive record or being reported to their insurance company. So that's option one, the deferred finding. Option two, you have an option to mitigate the case. Mitigate would simply be to state that the infraction happened, but ask the court to lower the fine. That does result in a finding of committed, but again, a lower financial obligation. It would go on your drive record. Third and finally, you have the right to a contested hearing. Once we start a contested hearing, the only thing the court can do is to find the infraction committed or not committed. There's no middle ground, there's no halfway, there's no, can we change the fine or cost? So between those three options, the deferred finding, the mitigation, or the contested hearing, how are you asking to proceed?
With a contested hearing.
Okay. I'm going to read the police report into the record, sir. Did you submit any kind of documentation for the court at all?
I did not.
All right, I'm going to read this into the record. This is the report of Officer Alex Martinez of the Richfield Police Department. It states on February 27th, 2023 at 9:45 a.m., I was dispatched to a non-injury traffic collision called in by a City of Richfield Public Works Supervisor, Kelly Melroy. Kelly stated that one of his co-workers was rear-ended at the roundabout at South Royal Road and Pioneer Street. Upon arrival, all the parties were out of their vehicles and appeared uninjured. I contacted the driver of the city fleet vehicle, Derek Smith, who was driving a Ford F-350 utility truck. He stated he was traveling from west to east on Pioneer Street when approaching the roundabout. He says as he pulled up to enter the roundabout, a Ford Flex was slowing down, making Derek believe it was going to exit the roundabout heading west on Pioneer Street. The Ford Flex did not exit as Derek anticipated, so as he was rolling forward, still out of the roundabout, he had to engage his brakes quickly. Derek stated this is when the other involved party collided with him. Derek and Kelly showed me the sustained damage to the city fleet vehicle. I observed a minor indentation and a red paint transfer onto the rear black bumper of the city vehicle. Kelly estimated the cost to replace the bumper would be about $800 to $1,000. I spoke with the other party who was standing by his truck, a lifted 2020 Chevrolet Silverado pickup, wearing Washington license plate. I don't need to give your plate number on the thing. The driver owner was identified as Joseph Burris. Joseph stated he had just dropped his daughter off at Union Ridge Elementary and was heading back to I-5. Joseph said he was slowing down as he pulled behind Derek's vehicle. He thought Derek was going to enter the roundabout, so he continued forward slowly. Joseph stated when he looked ahead again, he noticed Derek's vehicle had stopped and he had to slam on his brakes. Joseph said he did not have enough time to react after seeing Derek's vehicle stop, causing the collision. Based on the statements supplied by the involved parties, it appears Joseph did not allow enough space between his vehicle and Derek's while traveling on Pioneer Street. As such, Joseph has been issued infraction 3A0236-407 for violation of RCW 4661-145, following too closely. I certify or declare under penalty of perjury under the laws of the state of Washington that all statements made herein are true and accurate, and that I am entering my authorized user ID and password to authenticate it. Signature Alex Martinez, number 665, February 27th, 2023, City of Richfield, County of Clark, State of Washington. All right, Mr. Burris, you can go ahead, sir. Are you going to be offering testimony, sir?
I guess I just, the officer wasn't there to see the infraction.
If you're going to testify, I need you to raise your right hand. I need to swear you in, sir.
Yes, sir. Go ahead.
You swear to tell the truth, the whole truth, and nothing but the truth during this proceeding today?
Yes, I do.
All right, you may lower your hand. Go ahead.
Okay, thank you. Yeah, I don't believe I was following too closely. You know, the roundabout is a system where cars sort of accordion in and accordion out as they approach the roundabout. And I was doing my best to drive safely, but you know, it sounds like the car in front of me was not driving as anticipated, and it caused the driver in front of me to slam his brakes, and then me to slam my brakes. And you know, the damage sustained to his vehicle was very minor. I had quite a bit of space to slam the brakes and slide for a little bit. So I don't believe I was following too closely, and I think it was, you know, the ticket is based on an assumption, in my opinion.
Okay. So here's my perception. I wasn't there either. I think that the piece of information that I think is the most telling that it's in the report is the statement by the city employee
And could the city be heard briefly, Your Honor, when you're ready?
Sure.
Okay. Our contention would be that there is, regardless of any other potential hearsay, there's a statement of a party opponent where it says, quote, Joseph said he did not have enough time to react to seeing Derek's vehicle stop, causing the collision. That's the exact definition of 4661-1451.
Yeah, I was pulling up 4661-145. It says the driver of a motor vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of such vehicles and the traffic upon and condition of the road of the highway. So I think that what I'm seeing is certainly that the city employee had to slow in an unanticipated way. The notation that I am not seeing is that anyone had to slam on their brakes or something else that would be completely unexpected or unplanned. Very clearly, this was a fairly heavily traveled time of morning, 9:45 a.m. Clearly, by just the documentation that I have, there's at least 3 cars in the roundabout at the time. There's the Flex, there's the city pickup truck, and there is Mr. Russell's pickup truck, Mr. Burris, excuse me, pickup truck. So I have to look and say, the driver of a motor vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of such vehicles and the traffic upon and condition of the roadway. These roundabouts are complicated. Everyone needs to slow down in them. Very clearly, people are making assumptions in the roundabouts that are not correct necessarily. And so because of that, I think the following distance has to increase. Again, Mr. Burris notes he was slowing down when he pulled in behind the vehicle, continued slowly. When he looked ahead again, I don't know where he looked besides ahead again. He noticed the vehicle had stopped, had to slam on his brakes. I just don't feel like that definition of reasonable and prudent is met here, Mr. Burris. I am going to find the infraction committed based on the information that I have, sir. So, Mr. Burris, we're going to be sending you some information about the citation. Are you still on Northeast 5th Street in Vancouver?
Yes, I am.
All right, we'll send the information there. You do have the right to appeal my decision to the Superior Court in Clark County if you choose to, okay?
Okay.
Thank you, sir. Have a good day.
You too.
Okay. Is Mr. Johnson, are we ready to recall your matter?
Judge, I'm present. I'm actually still on the phone with my client. Does your honor have other cases that you can call?
Oh, yes, I do. We'll hold on. All right, thank you. I am seeing a CDL.
You are.
It's class, I mean, it's indicated on here that he was issued a Class A December 28th, 2021.
Okay.
Why it's not on the infraction, I don't know. That's
Okay. Yeah, the ADR had it both ways as well in my system.
okay, so let's call Mr. Elston, Brandon Elston.
Okay. In your honor, I'll bring up paperwork. This is a change of plea to DWS3.
Okay.
Our office has been in communication with Mr. Elston. He's told our office several times that he wishes to enter this plea without counsel. He has reviewed the paperwork. We did have him initial the PTA and the appendix sheet for DWS3, and it's contemplating 2 days of work crew.
Okay. Mr. Elston, I am going to go over with you your waiver to a right to an attorney before we do the plea today, just to make sure that you're understanding everything. If you do need to engage with counsel, then it gives you that opportunity. It states that you understand you're charged with the crime of driving while suspended in the 3rd degree as indicated in your citation and complaint. You understand the maximum penalties in Appendix A. It sounds like Ms. Carmi had you initial that. Sure. There are not any minimum penalties, so I'm going to skip that number 3. You have the right to an attorney to represent you at all stages in the proceeding. If you cannot afford an attorney, you have the right to request a public defender. If you qualify, an attorney will be appointed to represent you. You may be at a disadvantage if you proceed without an attorney. You'll be required to follow the laws and court rules which apply to this case or these cases. These laws and rules can be technical and complex. I may not fully understand them without an attorney. Number 6 says, I'm aware of the dangers and disadvantages of proceeding without an attorney. However, I choose to represent myself, knowing the risks. I waive my right to be represented by an attorney. Number 7, the court has had a colloquy or discussion with me on my rights to any attorney and my desire to waive this right. Number 8, no one has made any threats or promises to get me to waive this right. I'm doing this of my own free will. Would you like to still proceed on your own? Yes, sir. Okay. So I'm going to sign off that I have read this to you. And then if I could have you approach, I'm going to have you sign it as well. Okay. So come on up right here. Get your pen that works. So you're going to sign and then print your name. Which one? Thank you. Yeah, there you go. All right. Did I? Oh.
It's been a long.
It's been a long day. All right. All right, Mr. Elston, we're going to go forward now with your plea. You're Brandon James Elston. You're 38. You've completed high school. Is that correct?
Yes, sir.
All right. You able to read and understand the English language?
Yes, sir.
And in your plea today, you're giving up several important rights. You have the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you, the right at trial to testify and have witnesses testify for you. The witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand all those rights?
Yes, sir.
You understand that in pleading guilty today, you're waiving those rights.
Yes, sir.
The charge which you are pleading to is what is called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. There has been a pre-trial agreement handed forward. You understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law.
Yes, sir. I do.
Court can place you on probation for a time frame of 2 years, during which time you pay costs, fees, and assessments as authorized by law. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. To the charge of driving while suspended in the third degree, taking place March 20th, 2022 in the city of Battleground, how do you plead?
Guilty, Your Honor.
Are you making the plea freely and voluntarily?
Yes, sir.
Has anyone made any threats or promises to get you to plead guilty?
No, sir.
Factual basis states on or about March 20th, 2022, I drove a vehicle in the city of Battleground while knowing my license was suspended in the third degree. Is that a correct statement?
Yes, sir.
Will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. Is this your signature on the last page?
Yes, sir. It is.
All right. Anything you'd like me to know, Mr. Elston, before we enter the plea?
No, I drove without a license. I'm getting that stuff taken care of right now. This is part of that.
Okay.
I'm not driving.
Good.
So, that's all I can do.
Sounds good. Well, so I will follow the agreement of the parties. Driving while suspended in third degree, 90 days with 88 days suspended, 2 days to serve. Those 2 days can be served on work crew. I'm not sure who filled out the 200 days of work crew. Yeah, that's sometimes what happens when we have to go really fast. So it's 90 days with 88 days suspended, 2 days of work crew. I think Devin's here hopefully right now. You can get signed up for that. Well, you can get signed up at some point for that. $100 fine, to which will be added a $30 work crew fee, $43 conviction fee, $102.50 traffic penalty assessment, and a $150 filing fee, for a total fee or cost of $425.50. You're on bench probation for 24 months. We're going to set a review for July 13th, 2023 to make sure you've completed your work crew. Easiest way to cancel that court date is to do your 2 days of work crew. Okay. We'll give you some information on that, Mr. Elston. We wish you well. We'll get you some paperwork by the door.
Thank you, Your Honor.
Thank you. Have a good day.
You too.
Then I'll scan this up. You can type when you're ready. It's my last birthday and it's an entry of state for the pilot.
Okay, Mr. Kangas, come on up. And Mr. Kangas, I'm going to go through your waiver of right to attorney, and then we'll go through your stay if you still want to proceed. It states that you understand you're charged with the crime as indicated in the filing, which is reckless driving. You understand that there's a maximum penalty for that, along with the mandatory minimum penalty. Are you aware of those?
Yes, Your Honor.
Okay. You have the right to an attorney to represent you at all stages in the proceeding. If you cannot afford an attorney, you have the right to request a public defender. If you qualify, an attorney will be appointed to represent you. You may be at a disadvantage if you proceed without an attorney. You'll be required to follow the laws and court rules which apply to this case. These rules can be technical and complex. You may not fully understand them without an attorney. You're aware of the dangers and disadvantages of proceeding without an attorney. However, you choose to represent yourself, knowing the risks. You waive your right to be represented by an attorney. The court has had this colloquy or discussion with me on my rights to any attorney and my desire to waive this right. Nobody has made any threats or promises to me to get me to waive this right. I'm doing it of my own free will. You still want to proceed today on your own, sir?
Yes, Your Honor.
All right. And if you want to come forward, I'm going to have you just sign the waiver as well. There's a pen. You're going to sign there and print your name right there, please. No, that's all right. Okay. All right, Mr. Kangas, do you have that waiver of counsel? You and I are now going to go through your stay agreement. I always tell folks, as you heard me probably do a bunch of times today, I'm not a party to these agreements. This is a contract between yourself and the city of Battleground. I'm going to make sure you understand the terms of the agreements and we'll go forward from there. This is a 12-month stay of proceedings, during which time you'll be paying a $150 filing fee, a $150 supervision fee, so a total financial cost of $300. You're to remain compliant with your payment plan. You're to do 24 hours of community service. That can be at any nonprofit you choose. Please make sure you have documentation that shows where you completed, and I'd like to see that done in the next 3 months, okay? So you're gonna want to get started on that. You're to do the defensive driving class, level 2. You're not to drive without a valid license and insurance. You're not to have any new criminal charges, and you're to appear at all future court dates. You're giving up some important rights on this case. You're giving up your right to go to trial on the case. Do you understand that right?
Yes, sir.
Any questions about it?
No, Your Honor.
Are these your initials on the form right here?
Yes, sir.
Okay. You're also giving up your right to a speedy trial. Do you understand what that speedy trial right means?
Yes, Your Honor.
Are you in agreement with doing a waiver of that right starting a year from now, April 13th, 2024?
Yes, sir.
Do you have any questions about that right at all?
No, Your Honor.
And are these your initials right here?
Yeah.
Okay. This charge you are entering your stay on is what is called a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. Do you have any questions of the court at all before I enter you onto the stay?
No, Your Honor.
Okay, is this your signature on the last page?
Yes, Your Honor.
All right. We're going to set a review date for you, Mr. Kangas. That's going to be on July 13th, 2023. At that time, we're going to look at the community service and the defensive driving. Said defensive driving. I think it's traffic safety. Let me look. Nope, defensive driving level 2. Your final review is on the 11th of April, 2024 at 1:30. Again, those are mandatory court dates, sir, so make sure that you appear. You're going to get a copy of your documents today. If you have any questions at all about the proceeding today?
No, sir.
We'll get you some paperwork over by the door. Once you have it, you are free to go.
Thank you.
Mr. Johnson, can we call your infraction matter now? I have the officer still here waiting.
Yes, Your Honor.
All right, and how is, it looks to me like the court clerk has printed out Mr. Singh's drive record. It looks to me like he has a Class A CDL that was issued in December of 2021 and shows that it is current right now. Is that your understanding?
That is my understanding, Your Honor.
Okay, based on that, how are you asking to proceed?
Your Honor, could we, well, Your Honor, if the court would allow it, I could ask for a continuance. This would be the first setting of this infraction. I do have authority to do a waiver of speedy hearing. I do understand that the court, if the court wants to proceed with the officer present, I would just note that my preparation for this case was anticipating entering a deferred today.
Go ahead, Ms. Carmen.
Yeah, and if we did continue, I understand there was some confusion over the CDL issue. I believe Officer Dubiak is back on April 27 for a different contested hearing. So, and she was already planning to be here. So if the court is inclined to grant a continuance, the city does not object, and we could have both of those heard on the 27th.
Officer Dbiak, are you okay with that? I'm gonna assume her answer is yes. Are you okay with coming back on the 27th on this matter? All right, so we'll see you then. All right, Mr. Johnson, we will continue this under your authority to the 27th of April, 2023 at 2:30 p.m.
That was 2:30, Your Honor.
All right, thank you much. Have a good rest of
Thank
your
you.
day.
You too.
If you're interested in them.
You have the show, my friend. You have every
Well-
case that I have remaining.
Okay, that seems to be the case. So kindly, there he is. And so, Your Honor, this case is coming forth. It's a conflict case. And I apologize to Mr. Busby. He has emailed me about this case, asking for the status of it, and I just was only able to provide that status at this time. So ultimately, where we're at, I don't have my court file because it was called earlier this morning. I guess there was some confusion with Mr. Bernard's access of the Zoom hearing. I'm not really clear on that, but ultimately, we're hopeful that Your Honor will be amenable to hearing the matter right now and not speaking about any kind of release condition modifications based off of him being here present in court in person. And then logistically, he has some open felony matters that are of serious import. And so just we're asking to waive this matter out a little bit longer in time than would be typical out into June, because the hope is that there is an understanding of what's going to happen in those felony cases by that point. His next felony appearance is May 5th, and his understanding that appearance is scheduling trial. So that's what we're requesting. And then I didn't have the release conditions to fill out. I apologize about that, Your Honor. It's also on for sentence compliance, maybe with another case, and I would ask that we maintain the denials in that regard and continue that as well.
So, Mr. Bernard, before you leave today, we do need to get an address for you. You were supposed to provide that to us via email last time and didn't. So you need to write it down and give it to you right now, sir. No, you can do it with our clerks though in a minute. So, Mr. Bernard, do you understand your right to a speedy trial? Yes, sir. And it looks like from this document, you're agreeing to waive or begin that right on the 29th of June. Is that correct? Yes, sir. That would give the city of Richfield 90 days from that date if it became necessary to bring you to trial. Do you understand that? Yes, sir. All right, I will accept the waiver, find it knowing, intelligent, voluntarily made. On the clause number 21-6-001, we're gonna have Mr. Bernard back on June 29th, 2023 at 10 o'clock in the morning.
Sorry.
Go ahead.
My understanding is I only represent him on the open case, not on the sentence compliance case. So that's why that is only.
I'm gonna put both case numbers on the return to court form.
That's fine. I only filled it out as to one.
That's fine. I'll do the other. This is at 10 a.m. Okay. So again, you'll give our clerks the mailing address for you, Mr. Bernard. We've set your case over. Please make sure that you're timely to court next time. Okay. Right. Get you some paperwork by the door. Thank you, sir.
The card wise, all the office. They're on front line. And then, Your Honor, I have Kenneth Lowe. Okay. Honor, I was just appointed on this matter today, and I spoke with Mr. Lowe about his constitutionally protected rights to speedy trial. And so we're asking to set this matter over with a waiver to that next court date for my office to have an opportunity to review things with Mr. Lowe and speak with the prosecutor, which would be prudent and appropriate under these circumstances.
Mr. Lowe, do you understand your right to speedy trial, sir?
Yes.
And you're agreeing to waive that right starting on May 11th, 2023 to give Mr. Campbell some time to prepare for your case?
Yes, I am.
All right, I'll accept the waiver, find it knowing, intelligent, and voluntarily made. Mr. Lowe's next court date is going to be on May 11th, 2023 at 10 o'clock in the morning. Please make sure you're in touch with Mr. Campbell. We'll get you some paperwork and then you're free to go. Thank you, sir.
Okay, there's going to be some paperwork right over there. And then we go ahead. There's one up by the front desk, right by the front desk. Brandon Campbell, just like a suit. And then, Your Honor, we're going to recall Mr. Holland. And Your Honor, I greatly appreciate you identifying my ignorance in this case. That's obviously not my preference to be ignorant, but apparently I was and have to admit to that.
No, that's a problem. Like I said, I can't give legal advice, but
No, and
unfortunately, my one area of deep experience is DUI, so I
So,
just wanted to make sure.
Mr. Holland and I have discussed your concerns. I went and reviewed the statute, reprised myself, familiarized myself. This will burn his deferred for any future DUI. He's aware of that. And still in spite of that, and in spite of some reservations that he has about how this is all going to play out with the Cowlitz matter, there are certain benefits that he wishes to avail himself of in entering the deferred prosecution on the reckless driving matter. And the hope is, I don't believe that the waivers inherent in our case associated with not litigating actively certain things, I do not believe are binding on the probationary matter. And so if they file a contested motion and seek to admit the back certificate, we would then you'll call my office and either get an attorney up there or I'll go up there and help him to litigate certain stop and seizure issues associated with his stop and seek to avoid any kind of any sentence on the underlying probation, which is the benefit that he's hopeful to avail himself of not having the conviction in this case, even with the reduction in reckless driving.
Got it. And I'm gonna walk a fine line here, but I'm just gonna say, keep in mind, you're stipulating to the police reports when you're entering them, so you can't contest those police reports later.
Well, and that is true, and I think that is binding on this cause number. It may possibly not be, and he's aware that there's a potential for a probation violation. I think there's at least enough mud in the waters that in Cowlitz we can work to good effect if he's needing to seek some contested litigation in the probation matter on the search and seizure issue. Because while I would definitely be positive in this case, he could not bring that up if he was revoked on deferred. I'm not trying to hold that carrot out there for the court to have concern about. In our case, I don't think it's necessarily binding on the probationary matter in Cowlitz.
So, Mr. Holland, at this point, we've heard us all have quite a conversation about this today. It sounds to me like from the representation of Mr. Campbell that you're still asking to go forward and you're comfortable with doing that today, sir? Okay, I'm certainly not going to stand in your way. I'm going to go through the documents with you. I would note for the record, it looks like the document that we did receive from the Cowlitz tribe, to me, looks like it is sufficient for the deferred prosecution. Barely, but it is.
And there, just in full disclosure, there was an issue with one check mark that was not on the ROI, and it'll get fixed between now and when he's in compliance. It's just
So I'm just going to review with you kind of the rights and so forth you're giving up on this case. I'll walk you through the documents. If you need more time to talk to Mr. Campbell, you certainly can. One thing that we do talk about on this case, you are giving up your right to have a trial, a speedy trial. You can't call witnesses or contest this matter at this point. Simply, I'm not going to make any comment about what the Cowlitz judge will or will not do, but I want to make sure that that's part of our record. There are certain fees and costs that are associated with the case. There's a $250 breath test fee, a $200 emergency response fee, a monitoring fee of over $1,000 over the 2-year time frame, a public defender recoupment of $300, a filing fee of $150, and administrative costs of $250. Those are to be paid at $100 a month during the time you're on your deferred. You're to attend and complete a victims panel, abide by the conditions of your alcohol evaluation and treatment plan. You're to provide the court with monthly check-ins. Certainly, I'll be seeing you about every 3 months, so we'll be able to look into that. There's a couple parts here that I need to just kind of flush out a little bit. On the specific findings, it looks to me like it would be on the 28th of January. 1/28/23. You were charged with the following offense. We'll add reckless driving here now. That you do suffer from substance use disorders, that extensive and long-term treatment is called for pursuant your payment plan and available. You've stipulated to the admissibility and sufficiency of the facts contained in the police reports. You've acknowledged the admissibility and sufficiency of the stipulated facts in the criminal proceeding. If there's a revocation that goes forward. You've waived your right to testify, the right to speedy trial, to call witnesses. That your statements made in the police reports are knowing and voluntary, excuse me. If you fail or neglect to carry out any terms of the order, the treatment plan, or violates any of those orders, you can find yourself back in front of our court for a hearing to determine if you should have your deferred prosecution revoked or taken away. If we do revoke or take that step, we would just review the police reports to determine their sufficiency and probable cause for the charge of reckless driving. We will send notation to the Department of Licensing noting that you have entered the program on this charge. Oh, no.
Oh, no.
Okay. The
Okay.
problem with this is going to be that the deferred prosecution is a 5-year term. You only have 2 years of jurisdiction on a reckless driving.
Right.
So I can. Because even a DV has a 5-year term.
Correct, it's true.
I don't know if I can alter the statutory term of a true deferred prosecution.
Right.
So I guess we can effect a speedy trial waiver out to that date. It's pending a stay. So we could,
That would only get us to 4 years, even if he's revoked on the last day, though. But I guess
we could do a speedy trial waiver to 5 years from today's date. Would that be sufficient?
that would give the court her jurisdiction. Because otherwise, I'm not going to have jurisdiction for the 5-year term of a deferred.
Right.
Oof. Okay, yeah.
It's unclear to me, because in reviewing the statute, and so this is a little bit of a novel deal for me too. In reviewing the statute, it is clear that every Title 46 that has a prior deferred on it, so every traffic offense, whether it's misdemeanor, gross misdemeanor, that is deferred, burns the deferred for any future UI. So that's clear in the statute. So I don't know how that would be. I mean, that language wouldn't have any effect if you were not allowed to do a deferred on the reckless, if that makes sense.
No, I would agree with you completely. I think that the issue, though, is that for the things that the deferred is designed for, which right now in our state is DUIs and DV, the statutory probationary timeframe is 5 years, and it contemplates a 2-year treatment plan.
Correct.
It then contemplates 3 additional years of monitoring.
So would Your Honor like me to effect a speedy trial waiver? I can step briefly off with Logan and explain that to him.
I think we can do 2 things.
Can
We
you
can-
have a deferred prosecution that just lasts 2 years, or does it have to be 5 years?
So based on the statute, and I can pull it up,
I'll pull it up.
our document states that upon proof of successful completion with all terms of the court order and 3 years after the 2-year treatment plan is successfully completed, the defendant can request the charge against him or her in this case be dismissed. It appears that the condition precedent is the time frame, even if we get the treatment portion met.
And so, Your Honor, and this is, I guess, a little bit of a question that I've always had about deferreds, but the way that the statute is structured, if you look at 10.05.030, I think potentially the reason why it anticipates there not to be an issue on a simple misdemeanor, even being referred for deferred, for example, is that it's framed in the continuance of arraignment. So we've already proceeded with arraignment in this case and every other case that I've ever set on for deferred. However, the way that and it even contemplates entering a deferred 7 days before the trial day. So obviously arraignment has progressed, but the statute is then written in a way that talks about entering the treatment deferral period prior to arraignment. So there's no commencement date. So I'll defer to Your Honor on how you wish to proceed.
And I'm assuming that there was already a discussion of a stay of proceedings that would last 2 years and will be contingent upon the completion of his treatment program. And that would solve, and I'm not telling the city what to do, but that would solve the jurisdictional issue. It would not burn the deferred prosecution, and in listening to what Mr. Campbell's looking for, it would also not be a conviction in this circumstance. I think we would be on much firmer statutory footing doing it that way. But again, I'm not a party to a stay. I'm expressing concerns with what we're doing here using a deferred prosecution, but
Yeah, you're right. Right.
And I'm sorry, Judge, I know that this is taking up the court's time, and I greatly apologize.
I mean, I don't want to do the right thing.
Yeah.
I don't want to hurry.
Logan's been
into
on
just
screen now.
entering paperwork.
And it's really important that we get him off it just because of the financials. I mean, it's really burying him right now. So I would like to get this resolved today. And then in just fairness to the court, I think from a defense perspective, that idea is great, but I want to be also fair to Ms. Carney. And if we do the stay, that doesn't provide for the potential for this offense to be a prior offense, because it's not a conviction, it's to a reckless driving that then is dismissed, as opposed to being on the deferred, which the deferred would count as a prior. And so I'm fully in support of doing that, but I just don't want to, when we're doing something quick like this, I don't want to not be upfront about that.
Yeah, I mean, the other circumstance that you raise, in that scenario is that it also would enhance a DUI that took place in year 6 or year 7 on a regular deferred to 5 years of jurisdiction. And that's the intention of that. Anything within that 7-year time frame enhances upwards.
So unless, I mean, I guess,
This was a case where it was kind of coming in here today. It was going to either be a deferred prosecution on a DUI or a reckless driving
Correct.
plea. And we kind of crafted a stepchild of that, which is how we are here with this reckless deferred. So
I don't know if, I'm gonna tell the parties, I
Yeah.
don't know if statutorily I can do this Frankenstein outcome, whether someone wants it or not. I just don't think that, I mean, unless it's gonna be so murky if we do a waiver 5 years out to somehow extend jurisdiction on a case that's been dismissed.
I don't think that the dismissal occurs until after the 5-year window. So it would be waived out. The case would still be pending.
But the court wouldn't have jurisdiction then, Mr. Campbell. I mean,
Well,
I can't create 5 years of jurisdiction on a case where the court doesn't have it.
Well, I guess, and so possibly, maybe I'm misunderstanding or misreading this question, but if the case it's in a pretrial posture currently, he's been arraigned.
I
And
understand what you're saying. I think I understand where you're going, is basically that this is still not a reckless driving conviction. So
Correct.
jurisdiction won't have started running
until the commencement date,
until a commencement date.
and then there would be 90 days with which to revoke him on the deferred, is my perspective on that.
Okay. Yeah, I mean, that's correct. Someone's gonna be looking at this at some point going, what did they do?
we're all being very creative.
That's one word for it. So why don't you talk to Mr. Holland and talk to him about speedy trial?
Okay.
And I can keep your paperwork, or
I don't think I need the paperwork.
okay.
Find it helpful.
Okay.
And so, Your Honor, this is Wilson Ramos Carrillo. He's appearing with the benefit of an interpreter. He has been advised of his various rights tended to entering into a deferred and the waivers of those rights. Provided both the police report and an evaluation that I believe is sufficient for purposes of entering deferred. A recent treatment update to the court. And a certificate of completion of his victim impact panel. He's on quite a head start to the program as it stands. And so we'd be asking to enter the deferred today.
Mr. Ramos Carrillo, you are speaking to the court through a court certified Spanish interpreter. Are you able to understand her translation from English to Spanish? Have you had sufficient time to speak to your attorney, Mr. Campbell, about entry of your deferred prosecution today? Do you need any additional time to speak to him? There are two documents in front of the court. One is called a petition and the other is called an order. Did you have those documents read to you or did you read them yourself?
Yes, she read it.
So they were read to you in Spanish?
Yes.
Did you have any questions about the documents at all?
No.
I have reviewed the police reports as well as your evaluation and treatment plan. I do find that you do qualify for deferred prosecution. So the documents are stapled wrong. The cover of the order has 2 pages of the petition behind it. And the petition was on the cover of the order. Were these documents read in the order that they were stapled?
Yes, sir.
Yes, sir. I'll speak Spanish.
The good news, I believe, is that the statements on the first 2 pages are similar. It appears, Mr. Ramos Carrillo, that your documents were stapled out of order. Would you like to have the documents reviewed again with you in the correct order, or are you comfortable going forward?
No, that's fine.
It's been one of those days.
Like that track for today.
We are very consistent with our challenges today. Okay. So, sir, you have some obligations under the deferred prosecution program. You are to undertake and carry out the recommended treatment in your treatment plan. You're to maintain total abstinence from alcohol and other non-prescribed controlled substances. You're not to drive a motor vehicle upon a highway without a valid operator's license and proof of liability insurance. And you are to install an ignition interlock device. You have court fees, including a $250 breath test fee. A $200 emergency response fee. a $1,000 court monitoring fee,
$1,000 por la, estoy aquí la corte,
$300 public defender recoupment,
$300 por el abogado,
a $150 filing fee,
$150 por el archivo de documentos
and $250 of administrative costs.
y $250 por el costo administrativo.
You are to pay your deferred prosecution fees within 30 days at $100 per month.
Ustedes estarán empezando el. Can I interpret that question?
Sure.
Your Honor, what you're stating is that you will start in 30 days paying $100?
Yep.
Thank you very much. No, usted va a pagar esto pagando todo el instante, paga los $100 al mes empezando dentro de 30 días. Okay.
I have noted that you have completed the victims panel.
Yo he anotado que usted ya completó el plan de impacto de víctimas.
Please make sure that CMAR is filing monthly reports with the court.
Esté seguro que CIMAR le manda reportes mensuales a la corte.
The specific findings of the court are on or about
Los tiempos de la corte son
on or about January 29th, 2023,
el día 29 de enero del año 2023,
that you were charged with DUI,
que a usted se le acusó de haber manejado bajo la influencia de fuerzas intoxicantes,
driving while suspended in the third degree,
manejar bajo, pero con una licencia suspendida en tercer grado,
and an ignition interlock violation,
y también usted haber cometido agresión a la práctica como carro de agricultura usted está tomando,
that you suffer from substance use disorders,
que usted sufre de abuso de sustancias controladas,
that extensive and long-term treatment is required and available,
que a usted se le requiere y está disponible de un tratamiento largo,
that you are stipulating to the admissibility and sufficiency of the police reports
usted está estipulando la admisibilidad y suficiencia del reporte de la policía,
breath test documents
los documentos como sistemas de almacenamiento
for use in any future criminal proceeding.
y excluyen la población de cualquier procedimiento en el futuro.
You are giving up the rights associated with trial,
Usted está renunciando derechos y habrá un juicio.
if you fail or neglect to carry out any of the components of your evaluation or treatment plan,
Si usted sabe,
the court can hold a hearing to determine if you should be able to stay on your deferred prosecution.
la corte debe traer los documentos para continuar una audiencia respecto a los actos de la ejecución de la
Upon the successful completion
después de que usted se satisfactoriamente
of the 2-year treatment plan
los 2 años de tratamiento
and 3 additional years of probation,
y 3 años más de libertad condicional,
the charge in this case can be dismissed.
entonces este cargo se lo
Do you have any questions, sir, about any of the documents that we have gone through?
y las preguntas sobre los documentos que usted dio. No,
Do you have any questions for your attorney?
y las preguntas que usted nos abogado. No, I do have 2 questions. One is about my bail and the other one about this thing that I have in my book.
Okay, you can talk to your attorney about both of those when we conclude the hearing. He can answer those questions.
You're gonna need an exoneration bail because he paid a cash bond.
Okay, Madam Clerk, can we assist with that?
I'm sorry.
He paid a cash bond, so we need an exoneration, please.
It's on back to Mark on the 6th, we're on JNS.
But it's a,
There's not a JNS, it's a deferred prosecution.
Yes.
Thank you. We're going to be setting a compliance monitor hearing on July 13th, 2023 at 1:30 p.m. At 1:30 p.m. Please make sure you have updated documentation from CMAR on file with the court. We're gonna get you copies of all your paperwork over by the door. Once you have your paperwork, you are free to go. Thank you. Thank you. Good luck. Thank you, no problem. I'm gonna step off just for 1 second. Oh.
The issue is,
I think that that's 5 years on the first one.
I don't disagree with that. And I also don't disagree with procedurally what the judge's concern is. And so I think what it highlights is the issue, if you look at how the deferred process is statutorily designed, it is supposed to happen pre-arraignment. And so there is no commencement date. And so, I mean, arguably, every deferred has this special to attention after arraignment, because there's not a speedy trial, and it doesn't have any kind of speedy waiver entered into it after arraignment. But I mean, functionally, I guess that's a fight for another day. So I guess in the alternative, we could also, oh shoot, I probably should have marked that too. Well, it doesn't matter, it's in the other one. In the alternative, in the future, we could always walk back a plea, or I don't know exactly how that works. I'd have to look at it. I'll think about it. So we still have this matter and the Proud Mill case, and then I think we're docket complete. That's the problem. What is it?
I messaged her.
She's in trial. Yes, I'll provide the court some input. I'm gonna just ask for them. She might have to, and she is at trial.
Oh, she's out on that. Brandon, if you have proof of this victim's panel, you can send that to us. Yeah. I'm talking.
I know that it's still sorry. Yeah, I mean, I think that is something to reflect on the next time. Is all of the problems. you know, it's something, it's easy to kind of, I think that was all the time. I really want to give them strength. Everyone knows that you just don't have to come out. You know. It jams you up at work, it jams you up. All of it, so
And I know it next time, but it was too.
I've gone over this, I'll call it unorthodox resolution with my client numerous times. I believe he has a sufficient understanding of everything he's getting himself into today, as well as waiving his right to speedy trial out to 2028, which is by my math, the correct amount of time to give us a 5-year window on this deferred and make it clear that the court has jurisdiction. And so we'd be asking to enter that order today. And this matter will similarly need some form directed to Supervisor Lease authorizing him to take off scram so we can schedule an appointment with 2-Watch Monitor.
Mr. Holland, it's been a bit of a journey today, sir. Do you understand your right to speedy trial? Yes, sir. You understand that in doing a waiver starting April 13th, 2028, we're giving the city of Battleground 90 days from that date. It became necessary to bring you to trial.
Yes, Your Honor.
Okay. I will accept your waiver. I'll note it's knowing, intelligent, and voluntarily made. I made a notation at the bottom near my signature to extend jurisdiction to qualify for deferred prosecution per statute. So just in case I look at this in 2 years, scratch my head and wonder what the heck I was doing. That's my note to myself almost. Okay. I'm going to accept the waiver. Finding knowing, intelligent, and voluntarily made. I think we were pretty substantially through our form. Let me just make sure.
Is it the same issue?
Yeah.
I mean, they're so similar. I didn't notice that the bottoms.
Did you
were
staple
different.
these?
No. And I went through them verbatim with the client, so
Yeah.
I read this one and didn't even notice it.
Madam Clerk, we need to note, these are all stapled in the wrong order, the petitions and orders. So if we're handing these out in the future, they're wrong.
I guess I was confused by why there were factual findings in the petition. It makes much more sense that those are in the order and not the petition. I should have looked at the bottom.
Yeah.
footer.
I just knew that the only place the court actually signs is the order. So when I flipped to the petition and saw my signature, I thought I've either been doing it wrong for the last 21 years or the forms are wrong. Okay. Let's dive back in. I've gone through the fees and costs. We've gone through Mr. Holland's obligations to undertake his treatment plan, maintain total abstinence from alcohol, non-prescribed drugs, and controlled substances, not to drive a motor vehicle without a valid operator's license, proof of liability insurance, and installation of an ignition interlock device if ordered to by the Department of Licensing. We've gone through all the fees and costs. We've gone through the elements of the DUI, finding of a substance abuse disorder. We've gone through all of the compliance stuff. I think we were down to number 10, which stated that upon successful completion with the terms of the court order, and 3 years after the 2-year treatment plan is successfully completed, the defendant can request a charge against him and the case be dismissed. I'm making a note on here as well. Speedy trial waiver to fulfill jurisdictional shortfall. Layman's terms, we need to make this longer. It's too short to start with. Okay. Any questions, Mr. Holland, of the court or of your attorney before I sign you into the program?
No, sir.
All right. I'm going to see you next on the 13th of July, 2023 at 1:30 p.m. Please make sure that the Cowlitz tribe has a treatment plan. They're supposed to file them every month, and at least make sure I have one before that return court date to see how you're doing in the program, okay?
So like 3 weeks beforehand, I get one in 10. You're gonna direct them with an ROI to send it to the court, but you don't want to be beholden to them doing that, because we've had some difficulty. And we're not as familiar with that, so.
Okay. We're gonna get you copies of your paperwork, Mr. Holland. I wish you well.
And where she's gonna send pre-trial supervision email right now. So just go ahead and send it over and you can still get a phone number.
I'm glad every one of these is not like this. This one was we got a couple.
On things like this, which it does, why wouldn't there have been more, why isn't there clearer language in the statute about that 5-year issue for non-DV cases? Because it clearly says you can enter it for any misdemeanor, gross misdemeanor, or traffic infraction. So this clearly has had to come up before, it just hasn't come up in our court. But how, I'm trying to figure out where
Well, like I said, I think it's because it's designed to happen pre-arraignment. Like the whole petition and entry is typified in the terms of the statute is happening.
it does talk about continuing arraignment.
Yeah.
Anyway, I'll have to look into this. Something I'll do on the day off.
So I'm appearing on behalf of Miss LaValle for a client.
Yeah, it's not here.
No. And so I'd like to provide the court some information about that.
Okay.
So Miss LaValle, I believe, is she's either in trial or at trial dealing with she's unavailable today. And I have briefly exchanged a text with her about the client, and her representation was that she has been either in trial or at trial for the entire week and has not had an ability to reach out to the client that about today's hearing. Obviously, he signed a prior appearance. He's a retained client, as I'm aware. Miss LaValle did not indicate to me that the client has been out of communication with her. And from her negotiations with Miss Carmi, I interpret that she's been in good communication with the client. So I don't have information for the court about why the client would not be here today. And so I understand that this is a relatively a difficult case. And I guess I would ask Your Honor to consider a short set over with the failure to appear to be noted. And then I anticipate Ms. LaValle could be here next week to give the court in-person information about this, or I would be confident I could get a personal update or she doesn't have the type of files that many practitioners do. So not being in the office, I wasn't even able to get like a phone number for the client for me to call him today, which I certainly would have done. And so I'm just fearful that maybe there has been some intervening circumstance. And under these circumstances, I believe there are still pretrial, is he on supervised pretrial release, and there's been no violations?
Just an NCO.
Okay. There haven't been allegations of violation of the no contact order or things of that nature. I would ask Your Honor to consider not entering a warrant today.
I was looking to see if there was a phone number in the citation or the PC statement.
Or potentially even on the return to court slip. I didn't think to look in the court file. The client may have put some information down for his return to court.
I might have that.
Yeah, there is a phone number in here.
Can I step out and call him?
Yep. Right there. You can take that if you want. And this is,
We've done really pretty good. Oh, very good. I think we've done awesome. So.
this feels like though, it feels like the dream where like someone is chasing you and you like fall down and then like you're trying to run, but you're like stumbling. It just feels like we just have been stumbling the whole day. We're moving forward.
No, I think we've done.
Yeah. All right, so let's address the other two matters I have. I have Tyler Caps.
Yes. Mr. Caps. Oh,
I do have a statement in here that he has started his treatment as of April 4th. I was trying to look to see if we were going to waive his presence if he'd started treatment.
I don't think I have that treatment update, so I was.
It's just an email.
Okay.
Says helping professionals treatment started 3/1, need documentation by next court date. It is scheduled for today. There's an copy of his eval in here. And there is an email from Helping Professionals Wellness Center as April 4th that says Tyler has started his treatment. But I don't see anything where we are waiving his presence because he has.
Yeah, and I don't even, so I don't have that April 4th document. But I also don't see any indication that Mr. Capps was released from appearing today. And I do have some belief that he is non-compliant, although it's not something I can substantiate on paper at this minute.
So what is the city's position?
Well, at this point, we would ask for a warrant to issue in the standard amount at the very least.
All right. This is 2A0149-057 for Tyler Capps. Mr. Capps has court paperwork that says he'd be appearing today at 1:30 p.m. This was set over from a court appearance that took place back on March 2nd, so just a little over a month ago. We do have some documentation on the positive side of the ledger, but we don't have Mr. Capps here. Gonna issue a warrant in the standard amount for Mr. Capps. You ready to be heard on Mr. Cooper Smith?
Your Honor, unfortunately, it appears that that phone number, female answered the phone number and I couldn't readily speak to her. She was speaking in Spanish, but she did indicate that it was not a valid number for that client. So Alex was not able to be contacted on that phone number. And so.
And I'm trying to use a different.
Sure.
Oh, well, thank you. Was it 503-701-0127? 0127.
I think Ms. Travers has a different number.
Okay.
What she said.
All right. How about Timothy McKinney?
And you're on, oh, go ahead.
Yeah, Mr. McKinney was, I'm just gonna pull up his stuff here. Completed his 90 days of EHM, substance abuse evaluation, recommended treatment, victims panel. No substance abuse evaluation or updates on file. He fast finished his EHM. I would just say warrant issue in the standard amount.
Yeah.
Largely in compliance, though. Not over the majority of the hurdles. Mr. Campbell, you're back so fast each time. I'm assuming that number also didn't work.
Yes, we tried a different derivative of the original number that I tried, and that too was not a valid number for Mr. Cooper Smith.
Just giving you opportunities to meet new friends.
Yes.
I'm gonna look one more place, hold tight, where I'm gonna look in the file where he was the potential victim, and I did reach him back months ago. So let me just look. This is 503. Oh, I have a 360 number. Okay, I have 360
Because down
326 4191.
Oh, so it terminates the DUI monitor.
Yeah. I know, I'm trying really hard on it.
Okay. Looking through the
Right. Well, we tried.
Yes, Your Honor. That number went to a voicemail, but it didn't have any indication it would have been Mr. Cooper Smith, and I didn't see any utility in leaving a voicemail without being sure that it was him.
Okay. Right, in regards to the failure to appear, go ahead, Ms. Carney.
Yes, Your Honor, at the very least, we would note the FTA. I guess the city is somewhat torn on this, in that a defendant in a similar situation without a lawyer would have a warrant. The only reason that the city has some hesitation is because Ms. Lavalley did reach out to me last night. We are working on active resolution, and I know that she's had some things come up this week that have taken her attention. So I don't know what the right thing to do in this situation is, frankly.
Yeah, I think if someone didn't have an attorney, we wouldn't have any context for what's going on. In this circumstance, you have the context for what's going on based on your communications with Ms. LaValliere moving the case forward. We know that Ms. LaValliere has some personal and some work-related circumstances that are keeping her from being here and maybe engaging with Mr. Cooper Smith. So I don't think we're completely treating it differently because we have so much more insight into this circumstance. Let's set this matter over 2 weeks to the April 27th docket at 1:30. Certainly, if we don't have him here at that point, we will address a warrant at that time.
Thank you.
All right. And with that said, that concludes our docket. We can go off the record.
Guys.